Good evening all. On behalf of SIRC, I welcome everybody to today's program, Tax Planning on Capital Gain. I would like to request C. Krishnan sir to occupy the desk. I request members to raise for the motto song.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्मिमाणः निर्मिमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Thank you. Today I would like to welcome C. Krishnan sir. C. Krishnan sir completed his chartered accounting course in the year 1974 and immediately set up his office in Chennai. In the last 50 years, he has handled statutory audit, tax audit, internal audit of banks, hotels, and other industrial concerns. However, his specialization and interest has always been on capital gains in direct taxes and work contracts in indirect taxes. Capital gain tax planning is his areas of specialization. He advises his clients on capital gain tax planning and spends more time in his special area by contributing to various tax advisory magazines. He has been doing a lot of analytical research and keep himself updated on various court decisions relating to capital gain tax issues. He has been writing for taxman publications pertaining to capital gain issues arising under various sections of the Income Tax Act, like joint development of property, taxations of income of NRI, withholding tax under Section 195 of Income Tax Act 19 Income Tax Act. Okay. He has recently authored a book on capital gains and it has been published by Taxman Group of Publications for the third year in succession. He firmly believes that one should keep on updating himself on a continuous basis as each issue with arises on subject of capital gain taxes is unique in nature. I welcome on behalf of SIRC to this program, sir. And I also request C.A. Sundaramurthy sir to give away the memento to the speaker, sir. Yep. Sir, I would like to speaker. So, sir, you can continue this program.
So, good evening, all of you. I thank SIRC for having given me an opportunity to do presentation here. It was way back in 2013 when I got an opportunity through Mr. Prasanna Kumar, who has been elected as a Vice President today, to address on the same subject, capital gains. So no, there has been a lot of advancement after probably I gave a lecture in 2013. This joint development concept was not very much prevalent at that time. Now joint development agreement occupies an important pivotal role, whereby the landowner hands over the property to the builder stroke developer to develop the property, and he gets a certain portion for the certain portion of the land transferred, a few flats. Some of the cases there is cash consideration and also rental compensation. So we will see, there have been two Supreme Court judgments. One was given in Balveer Singh Maini, the other was given in Seshashahi Limited, Let us see whether these two judgments have altered the concept of transfer so far as capital gain is concerned. So we will go into the subject straight away. If time permits, then I would like also to go through the amendments that have been made by the Finance No. 2 Act 2024. Now, you can stop me at any point of time. I'll be just going through the slides. You can stop me, ask me any question. If I am little fast, you can tell me. Let me try to slow down a little bit. So, a joint venture versus joint development. Joint development is a popular method of development of property. So all of us know. Here an owner of a site with an existing house built on it, the house may be an old house. However old the house may be, it is better the house is not demolished before handing over for joint development. The house is demolished and then only the site is handed over for joint development. You are caught by the provisions of section 54F, where there are restrictions with regard to the number of properties to be held by you, and you will not be able to claim exemption for two houses. If the value of capital gain is less than 2 crores, you can claim exemption for 2 crores if you hand over land and building. So however dilapidated the building may be, it is advisable to hand over land together with building, and let the schedule in the joint development agreement incorporate it has been handed over along with building. If probably the rules permit, you can also say approximately how many square feet of a building is there. So joint development is a popular method of development of property. An owner of a site with an existing house built on it and a builder developer come together to enter into an agreement to develop a property jointly. The land is provided by the owner. The developer provides his expertise and spends money in developing the project, and the constructed flats are divided between them in a predetermined way. Let us understand the difference between a joint venture and joint development. Sometimes we loosely use both the words, but both the words are not synonymous. Though these two terminologies, joint venture and joint development, are often used synonymously, there is a difference between the two. A joint venture is applicable to every kind of business. So joint venture, A and B enter into joint venture and carry on business, so any kind of business. But a joint development agreement is the one which is restricted to real estate sector only. A joint venture is an agreement between the parties primarily characterized by shared ownership, returns, risks and governance. That is, the ownership, both of them become owners, the returns, risks, etc. are being shared by them, and the governance will be there from both sides. It will not be wrong to say that a JV is basically sharing a business, which is a method of devising equality rights of a business. However, in the case of joint development agreement, there is no sharing of business, and there is no element of business in such a type of arrangement. Instead, it is characterized by contributing to a business. Unlike the former, that is, unlike joint venture, this is a method of devising profitable rights of business. In a joint venture, there is a new separate entity, or in some cases called a special purpose vehicle. A special purpose vehicle is also called a special purpose entity. It is an entity created separately by a parent body to isolate financial risk. That is, some of the governments create the special purpose entity or the special purpose vehicle, so that any loss that arises out of it is borne by the person to whom it has been, with whom an agreement has been entered into. So its legal status as a separate entity makes the obligation secured even if the parent body goes bankrupt. On the other hand, a joint development agreement does not create any separate entity, as it is simply an agreement between two parties. In fact, joint development agreement is nothing but a barter. I bring land, you bring your expertise, I hand over land to you, you construct buildings on the land on the portion of the land handed over by me, then you give me all predetermined, say 2 houses, 3 houses, or any number of houses, plus a little bit of cash consideration, plus nowadays they also give this rental compensation. So everything is predetermined and everything is entered into. So it is simply an agreement between two parties. One of them has to be a real estate developer. A JDA is one where one party generally contributes the land and the other, being the developer, develops it accordingly. The responsibility of taking necessary approvals, development, marketing and launching of the project is all undertaken by the builder developer out of his packet, whereas no license is required in the case of a joint venture. The profits are shared by the parties at the end of the project in the case of a joint venture. So A and B, they enter into a joint venture, develop some property, sell the flats, then at the end of the year they share the profit and losses in a predetermined manner. But in the case of JDA, only one contributes, the other person develops, and it is the responsibility of the developer stroke builder to obtain all necessary approvals and market the product and incur all expenses that are required to successfully complete the project. The JDA is a need to be registered as a necessary precondition to receive loans from banks. In the event of a dispute in the case of joint venture, arbitration or mediation is considered to be the most feasible method. Thus, it is generally held to have a compulsorily an arbitration clause when it comes to JVs. The disputes arising under such kind of arrangement between the parties who incorporated under the Companies Act 2013 are to be decided by the National Company Law Tribunal, which has a sole discretion with respect to those disputes in the case of joint venture. On the other hand, disputes between the parties to the JDA can be entertained by the principal court having civil jurisdiction or the consumer forums if the owner claims unfair trade practices and deficiency services rendered by the developer. The governing authority in the case of JV is usually the Companies Act or Partnership Act. In the case of JDA, there is capital gain liability to the owner of the property, be it land or building or land and building. Whereas it is not so in the case of JV, where surplus will be taxed as business profit. I think there is no doubt about it. In the case of JV, whatever profit that arises at the end of the year, they share it, so it is taxed under the head business income. Here in this case, in the hands of the owner, it is capital gains liability. In the hands of the developer, it is business income. A JV can be brought into existence in the following ways. Purchase of interest in the local company by a foreign purchaser, local firm acquiring an interest in an existing foreign firm, both foreign and local entrepreneurs jointly forming a new enterprise. In the case of JDA, there is an agreement between the concerned parties. So let us understand what is JDA. So up to this, it's all preliminary things. I don't think there is any doubt. Now, the Supreme Court in the case of CET versus Balbir Singh Maini, 2017, 86 taxman.com. In all my references, I always refer to taxman.com because I am attached to Taxman. I contribute articles. I should be more faithful to the person who gives me an opportunity to write articles. So, judgment dated 4th October 2017 has given a new dimension to the concept of transfer under Section 247(5) of the Act after an amendment to Section 53A of the Transfer of Property Act, shortly referred to as TP Act, as well as Section 17 and 49 of the Registration Act with effect from 24th September 2001. There was an amendment made to the Transfer of Property Act and Section 17 and 49 of the Registration Act. We will see what amendments have been made. The Supreme Court in the case of Balbir Singh Maini held where for want of permissions, entire transaction of development of land envisaged in joint development agreement fell through, there will be no profit or gain which arose from transfer of capital asset which could be brought to tax under Section 45 read with 48. Suppose the joint development agreement fails, what happens? So when there is no transfer, the Supreme Court goes on to say when such a transaction fails, there is no transfer of property. It refers to the earlier decision from E.D. Sassoon and Company which defines what is income. The Supreme Court in this case observed that an agreement of sale which fulfilled the ingredients of Section 53A of the Act, TP Act, was not required to be executed to a registered instrument prior to the registration and other related laws. Prior to 2001, there is no need to have the agreement to be registered. After the amendments were made simultaneously, Section 53A of the Transfer of Property Act and Section 17 and 14 of the Registration Act, when agreement is not registered, it shall have no effect in law for the purpose of Section 53 of the Transfer of Property Act. In short, there would be no agreement in the eyes of law which could be enforced under Section 53 of the TP Act. This being the case, In order to qualify as a transfer of a capital asset under subclass 5 of section 247, there must be a contract which can be enforced in law under section 53A of the TP Act. A reading of section 17(1)A and 49 of the Registration Act shows that in the eyes of law there is no contract which can be taken cognizance of by the purpose specified in 53A of the Transfer of Property Act. That is, after 2001 September, the agreement is not registered, then it cannot be treated as transfer as per section 53A of the Transfer of Property Act. The expression of the nature referred to in section 53 and subclass 5 of 247. Okay? See, the most important section so far as transfer is concerned is 2 subsection 47 subclass 5. The expression of the nature referred to in 53 and subclass 5 of section 247 of the Act cannot be stretched to refer to an amendment that was made years later in 2001, so as to then say that though the registration of a contract is required by an amendment of section 2001, yet the expression of the nature referred to would somehow refer to only to the nature of contract mentioned in section 53A, which would then require not registration. That is, any transaction entered into prior to 2001 does not require registration. The following principles emerge from the reading of the judgment very carefully. Under subclass 6 of section 247 of the Income Tax Act, any transaction which has the effect of transferring and enabling the enjoyment of any immovable property will come within its purview. The expression or in any other manner whatsoever in subclass 6 will show it is not necessary the transaction refers to the membership of a cooperative society. So in this case, the shares in a cooperative society were transferred, and all transfers related to a cooperative society, and the transaction finally fell through. The object of subclass 6 of section 2 subsection 47 is to bring within its net a de facto transfer of any immovable property. The expression enabling the enjoyment of takes color from the earlier expression transferring. So enjoyment has got relation to transferring, so that it is clear that any transaction which enables the enjoyment of immovable property must be enjoyment as a perpetual owner thereof. The idea is to bring within the tax net transactions where, though the title may not be transferred, there is a substance of transfer of title in fact. So there is a difference between the Sale of Goods Act and the Income Tax Act. Income Tax Act, even if the sale agreement is not registered, if the other party is put in possession of the property, then the transfer takes place. The sale, suppose the property put in possession in the month of March, the sale takes place in April. The liability to capital gains tax arises in the month of March itself, the current year itself, not in the later year. For the purpose of sections 45 and 48 of the Act, some real income must arise. So that's what Supreme Court says. Some real income must arise on the assumption there is a transfer of capital asset. If there is no transfer of capital asset, there is no question of income. This income must have been received or must have accrued. So there are two types. One is the income is received by you, or the income must have accrued to you. The income may be received by you later as a result of this accrual. This income must have been received or must have accrued under section 48 of the Act as a result of transfer of the capital asset. The income from capital gains on a transaction which never materialized. So when the transaction itself did not materialize, there is no question of any income. At best, it can be called only an hypothetical income. Hypothetical income is no income at all. The Supreme Court referred to the accrual of income, referred to the earlier decision in the case of E.D. Sassoon was a CIT. So at that time, taxman was not in existence. So 1954, 26 IT or 27, wherein it was held. It is clear, therefore, that income may accrue to an assessee without the actual receipt of the same. The assessee acquires a right to receive the same. The income can be said to have accrued to him, though it may be received later on being ascertained. The basic conception is that he must have acquired a right to receive. So unless a right to receive income accrues, there is no question of taxing it in the hands of the recipient. Even though he has not received it, he is going to receive it on a later date. The basic conception is that he must have acquired a right to receive the income. There should be a debt owed to him by somebody. There must be, as is otherwise expressed, debitum in presenti, solventum in futuro. That is, the debt has occurred today, but the amount is going to be received in future, etc. Unless and until there is created in favor of the assessee a debt due by somebody, it cannot be said that he has acquired a right to receive the income or the income has accrued to him. at all. So the Supreme Court has very clearly held in this case, because the transaction fell through, it has referred to the earlier decision in the case of E.D. Sassoon and what is meant by accrual of income. When the income itself has not accrued, there is no question of any transfer. So there have been number of decisions after Supreme Court decision was rendered in the case of Balbir Singh Maini. We will go through a few of the decisions and find out how Supreme Court decision has been interpreted by various courts, and at the end of this I will offer my suggestions what would be a safe way of probably doing things in joint development agreement. These are all my personal views. The ITAT Pune bench in the case of Appa Sahib Baburao Lankar versus ITO held that when the assessee did not receive any monetary consideration towards sale of land, as checks given by the purchaser were stopped for payment and possession of land was under dispute, and parties approached the court to decide differences that arose between them, no profit or gain which arose could be brought to tax under section 45 of the Act, read with section 48 of the Act, since transfer of land did not materialize. So checks given by the purchaser were stopped for payment, and the possession of the land was also under dispute. The parties approached the court. So there is no question of any transfer. That this is what the ITAT Pune bench held. Then in the case which arose in the case of K. Vijayalakshmi versus Assistant CAT, ITAT Hyderabad, the facts were that under a development agreement, the assessee permitted the developer to enter premises of its plot to do all necessary things for construction of apartments. The assessee relied on the decision of the Supreme Court in the case of Balbir Singh Maini that agreement through JDS did not give rise to capital gains. The tribunal repelled such an argument after observing that the transaction fell through in the case decided by the Supreme Court in the case of Balbir Singh Maini, which is not the case here. Here this law has allowed him to enter into his premises, and all necessary things that are required for construction were also obtained. And he, in spite of that, he relied upon the decision of the Supreme Court in the case of Balbir Singh Maini. The tribunal repelled such an argument, and after observing that the transaction fell through in the case decided by the Supreme Court was not the case here, held that it could be said the assessee did hand over possession of the plot to a developer, that there was transfer as per section 2, subsection 47, the same was taxable as capital gains in the year in which the agreement was entered into. See, if we take a stand that there is no capital gain and we don't report any capital gain, suppose we report capital gain in a later year, the officer finds and also tribunal finds that the transaction has taken place in an earlier year, then there will be total chaos. There will be interest, there will be penalty. Then what would happen to the income that you have offered in the other year? So we have got to be very careful when you deal with joint development agreement. So all these things are only indicative factors. Each case has got to be decided based on the facts obtaining then. And it's better, all these case laws should be used only as, should not be used as sword. They should be used only as a shield. So, and it's always better to also refer to case laws. Let us not become case laws. Let not our case go up to the tribunal or the high court stage and then we get relief. Because normally it takes about 6-7 years to get the final relief. In this case, the tribunal relied upon the decision of the Andhra Pradesh High Court in the case of Potla Nageshwara was a deputy CAT, wherein it was held that when transfer of capital asset was complete. You must note the decision in the case of Balbir Singh Maini was given in 2017, whereas the Andhra Pradesh High Court in the case of Potla Nageshwara decided in 2014. So it was the decision of the Supreme Court is decided later, then this decision of the Andhra Pradesh High Court was rendered earlier. But the tribunal relied on the decision where the High Court has held when transfer of capital asset was complete, sale consideration had to be taken into consideration for the purpose of assessment, even though payment of consideration was deferred till other assessment year. Then, in the case which arose before the Calcutta High Court in Mallika Investments Company versus ITO, the admitted fact was the document in question was an agreement or agreement of assignment of property, wherein the assessee has held only the leasehold rights, and the same was also not registered till 31/3/2008. the assessee received certain amount by way of assignment of right. The assessing officer held that consideration was received during the relevant assessment year, possession was also handed over during the relevant assessment year, there is deemed a transfer of capital asset within the meaning of section 247(5) read with 53A of the TP Act. The tribunal held that as a possession which existed earlier, that an agreement of sale which fulfilled the ingredients of section 53A of the TP Act was not required to be executed through a registered deed, changed by the Registration and Other Related Amendment Act. No case of transfer of property was made under this act, so allowed the appeal of the assessee. So in this case, nothing was registered, and it referred to 2001 amendment, and the tribunal held that no transfer of property took place. Any questions so far, sir, or ladies? Then, Principal CET was Fardeen Khan. It's a decision given by the Bombay High Court. The assessee in this case had entered into a development agreement with the builder developer wherein land owned by the assessee was given for development. In terms of the development agreement, a certain amount was paid as a deposit to the assessee by the builder. The agreement inter alia also gave powers to the builder to obtain various permissions, commence construction of homes and sell them. There are other conditions with regard to the adjustment of notional cost and sale price of the property proposed to be constructed. So in this case, a joint development agreement was entered into, and certain amount was paid as deposit to the assessee by the developer, and the assessee also gave certain powers to the developer to obtain various permission, commence construction, etc. There are also other conditions with regard to adjustment of notional cost. What will be the approximate transfer cost, etc. So everything, these were the facts of the case. So based on all these facts, the assessing officer brought the amount received by the assessee to tax. The tribunal decided in favor of the assessee by holding that where assessee, owner of a piece of land, entered into a development agreement with the developer for a specific purpose to develop land, and possession of land continued to be with the assessee, there was no transfer in terms of section 247(5) of the Act. So the tribunal referred to an earlier decision given by it in the case of Fardeen Khan. So when the issue was taken to the Bombay High Court, this is what the Bombay High Court probably, on noticing that only license was granted by the builder developer, the possession of the said land continues with the assessee. Further, the proviso to clause 6 of the development agreement clearly provides that nothing contained in the agreement shall be construed as grant of possession and part performance of the agreement under section 247(5) and 247(6). So it held that as no transfer of the said land had taken place under the development agreement, the occasion to compute capital gains as proposed will not arise. The High Court went on to hold at para 14 that when it is already held that no transfer of land has taken place into the agreement, there is no question of bringing any money into capital gains net. Then this is an important decision given by the Delhi bench in the case of Samag Developers versus Assistant CIT. So it had referred to the earlier order in the case of the same assessee for a different assessment year, and held that where the assessee entered into shareholder agreement with a financial partner for development of integrated township and handed over land for development, he knew the fact that the transactions embodied in shareholders agreement were unregistered agreement, provisions of the section 247(5) would not be applicable. Then the ITIT bench Delhi in the case of Madhu Gangwani held when possession of the property was handed over to the purchaser on full payment of sale consideration, and sale was executed on 31/3/2009, while it was registered on 1/4/2009, next financial year, capital gain would be chargeable to tax in the assessment of 2009-10 pertaining to 31/3/2009. That is, when the handing over was done, the transfer has already taken place, not in 2010-11 when it is registered. That's what I told in the beginning. The tribunal also relied upon section 47 of the Registration Act, which states that registered documents shall operate from date of execution. All of us should remember, we may have the sale deed registered on a later date, even if in the same financial year. The date of registration of document always relates back to the date on which it was executed. So there are normally the date of execution and the date of registration would be same. But when both of them are not same, the date of registration would be a later date then it relates back to the date of execution of the document. Tamil Nadu Brick Industries versus ITO. In this case, the tribunal held where pursuant to a joint development agreement entered into by the assessee with the developer, it was agreed that 60% of constructed area would be retained by the developer, and the general power of attorney was also executed, in terms of which developer was conferred complete rights to deal with landed property in any manner. It will amount to transfer of property within the meaning of section 247(5). So all the ingredients are there. See, in this case, 60% of the constructed area will be retained by the developer, and a general power of attorney was given to him, as per which he was conferred all the rights to deal with the landed property in any manner. It will amount to transfer of property. The following are the observations made by the tribunal, which are worth noticing. It was contended by the learned counsel under commencement and completion of construction of the written submission that the owners have permitted the developer to enter and exit the scheduled property for the purpose of development only, provided always that the same shall not be construed as delivery of possession. See, there is a saying in Tamil, see policy vacha Kalyanam is not going to stop. Like that, by merely stating that possession has been handed over, you cannot escape. Provided always that the same shall not be construed as delivery of possession or part performance contemplated under section 53A of the Transfer of Property Act. The owners hereby permit and authorize the developer to enter upon the scheduled property only for the purpose of development. The above submission is not acceptable because upon execution of registered GPA by document such and such, upon obtaining statutory approvals, the developer shall be entitled to sell, convey or deal in any manner the 60% undivided share or such proportionate share in the scheduled property by using the GPA granted by the assessee to the owner. In fact, whenever a joint development agreement is drafted by an advocate, it is better that it is vetted by us also, because the advocates probably are more competent so far as the registration and other things are concerned. But so far as Income Tax Act is concerned, probably we should sit with the advocate, or we'll have to say it has been, don't say it is modified, some suggestions are made so that some of the classes can be deleted, some of the classes can be added in such a way that either the possession of the property is given or the possession of the property is deferred to a later date. It has to be worded very carefully. So in this case, the developer did not come out due to delay in obtaining statutory approval. See, in the case decided with the Supreme Court, the whole transaction fell through. That's why Supreme Court said there is no transfer, there is no question of any income, real income or accrual of income. So in this case, the developer did not come out due to delay in obtaining statutory approvals from authorities. More so, once a registered GPA alone confers entitlement to the developer to sell, convey or deal in any manner 60% of the undivided share, etc., it shall be very well construed as nothing but transfer of property within the meaning of section 247(5) of the Act. In this case, the assessee had executed 3 documents on 17/9/2012, out of which 2 documents are registered GPAs and another one is JDA. If all these documents are conjointly read, it can be said there is transfer of property under section 247(5) of the Act, whereas in the case of Balbir Singh Maini, Supreme Court, there is no single registered document available. Therefore, this case has got no application to the facts of the present case. We should also know which are the decisions that are against us, so that we don't fall into the pit. Now, Gurudev Singh versus ITO. The facts obtaining in this case are unusual. The assessee, a rustic villager, received an advance for sale of his property and did not even hand over possession of the property, as he could not give satisfactory explanation because of unusual circumstances with regard to the amount. See, he had received certain payment and he did not hand over possession, and he was not aware what sort of explanation we should give. On finding so much of deposit in his account, addition was made by the assessing officer, which was also confirmed by the First Appellate Authority. But the tribunal did a very nice work. As he could not give satisfactory explanation because of unusual circumstances with regard to the amount of deposit that was reflected in his bank account, the deposit was added to his income and penal proceedings were initiated against him for concealment of income. The facts of the case were then cogently analyzed and listed out by the tribunal while reading the penalty order, and after referring to the decision of the Supreme Court in the case of Balbir Singh Maini, observed as under. However, in view of judgment referred to above, We are of the view that because the assessee sold his property by making unregistered agreement to sell and received part payment only, and somehow the said deal could not be finalized, therefore he, under the impression that he will return the earnest money to the buyer, therefore has not shown the said amount in his income. Whatever the representative should have argued, the tribunal was arguing on behalf of the assessee. So he has not shown the said amount in his income, although the said circumstances have been explained to the revenue authorities, however did not yield any result. Therefore, we are of the considered view that the penalty proceedings are quasi-criminal in nature, cannot be fastened only on the probabilities and from the facts as emerged. The assessee has not concealed any particulars of income. Hence, we order deletion of penalty. We do not know. Probably the assessment must have been confirmed. We do not have facts about that. Now, this is an interesting case decided by the Chennai bench. The dispute which arose in the case of Deputy CAT versus Sadak Ahmad Shah, decided by the ITT Chennai bench, related to the year in which the transfer took place. So, when did the transfer take place was a dispute. The assessee entered into a joint development agreement on 27/6/2006 with the developer, as per which 50% of the land was handed over for development. The developer in turn was to hand over specified area of constructed building consisting of residential and commercial space to the assessee landowner. Consequent to the JDA, the assessee had filed his return of income for the assessment year 14-15 declaring capital gains. See, the agreement was entered into on 27/6/2006 pertaining to the assessment year 2007-8. But the assessee had filed his return income for the assessment year 14-15 declaring capital gains. The assessing officer, while completing the assessment for the assessment year 2014-15, invoked the provisions of section 50C of the Act, adopting guideline value for any assessment year for the assessment year 2014-15 under the pretext that the transfer had taken place during the assessment year. The assessee himself had declared capital gains for the assessment year 2014-15, even though he had entered into the agreement on 27/6/2006, as per which 50% of the land was handed over, and he was to get back some residential as well as commercial buildings. Now, the Commission of Income Tax, relying on the order passed by the coordinate bench in the case of Shafiq Mohammed Shah, etc., allowed the appeal of the assessee. The coordinate bench observed that the legal ownership continued with the owner to be transferred to the developer at a future distant date, really did not affect the applicability. So, see what you see, the coordinate bench observed the legal ownership continued with the owner to be transferred to the developer at a future distant date, really did not affect the applicability of section 247(5) of the Act, as the owner entered into an agreement for development of the property and certain rights have been assigned to the developer, who in turn had made substantial payment, consequently entered into the property, therefore taken steps in relation to construction of the property, including applying for project plan approval. So, even though the assessee had declared income for the assessment in 2014-15, probably he has received his stand before CET appeals. The CET appeals allowed the appeal, saying that whatever thing that has to be done for transfer of property had already taken place in the assessment year 2007-8. The coordinate bench ultimately held the argument that the deeds in respect to sales were not registered is not a relevant consideration so far as provisions of section 247(5) are concerned. The completion of transfer of an immovable property as per the general law is not requirement for the applicability of the provisions of class 5 of section 247. So, general law is different from Income Tax Act, or the Income Tax Act is different from general law. The taxability long-term capital gains could be taxed only in the financial year 2006-7, relevant to the assessment year 2007-8, ordered accordingly. The departmental representative relied on the decision of the Supreme Court in the case of Balbir Singh Maini. This decision was rendered by the Supreme Court in October 2017, and while the decision which was referred to by the CET appeals was a decision of the tribunal given prior to the decision of Balbir Singh Maini. So that is what the department representative says, that the Balbir Singh Maini decision was rendered on 4/10/2017, which was not available when the order was passed by the coordinate bench in the case of Shafiq Mohammed Shah on 11/5/2017, for the proposition that the transfer took place only later, not when possession was given by the assessee. So this is the tribunal prepared an excellent chart to distinguish SSC's case from that of the Supreme Court, the case of Balbir Singh Maini, on the following lines. So BSM means Balbir Singh Maini, denotes facts of the case in Supreme Court case, Balbir Singh Maini. A denotes facts in this case. So BSM, that is Balbir Singh Maini, the developer in that case had not done any act in furtherance of the contract. But in this case, the developer did so many acts in furtherance of the contract. Then in Balbir Singh Maini case, the developer did not fulfill his part of the contract, he ran away, the project was abandoned. This developer did perform his part of the contract. BSM, the landowner continued to be the owner throughout the agreement and there was no transfer of rights. In this case, transfer of rights were given to the developer as per JDA. Then Balbir Singh Maini, the JDA fell through, the transaction never materialized and no income accrued at all. In this case, the JDA did not fall through. The JDA was completed and the income accrued in this case became taxable, the assessment at 2007-8. Balbir Singh Maini, the assessee did not acquire any right to receive income which was dependent upon the necessary permissions being obtained. In this case, the developer acquired the right to receive the income on the date of signing of JDA. The tribunal also noted that only one common fact in both the cases that the JDA was not registered, but all other facts are totally different. So all these things actually must have been prepared with the representative of the assessee, and the tribunal has prepared a neat chart and then has decided in favor of the assessee. The tribunal also noted that the department started to tax the capital gains on the basis of actual registration date of residential units and commercial area in the respective assessment years as per the directions of Honorable ITAT in the case of co-owner. That is, based on the decision given in the case of the other co-owner, they were taxing the sale of the houses which have been obtained as a result of JDA in the years in which they were sold. So they cannot take an inconsistent stand. The tribunal then referred to the decision in the case of Balbir Singh Maini and held that in that case before the Supreme Court the transaction did not materialize. The Supreme Court held that capital gains could not be taxed, whereas the facts in this case were totally different in the sense that all was listed out in the table had materialized, resulting in transfer of capital asset during the assessment year 2007-8 itself. The tribunal thus distinguished the decision of the Supreme Court in the case of Balbir Singh Maini and dismissed the appeal of the revenue. So any questions so far, sir? Yes. Just 1 second.
Sir, most of these decisions are individual assessees. After introduction of 45(5)(a), will this hold good? Because 45(5)(a) makes it very clear, overriding 247, you have to go and see when the project is completed and completion certificate issued by the competent authority. So all these decisions still hold good if it is an agreement which is registered.
Suppose I don't register my JDA.
Yeah.
All these decisions
unregistered agreements only. Registered agreement 45(5)(a) will prevail.
And to share a secret with you, very few builders in Tamil Nadu registered JDA. I think it is a bit expensive. In states like Telangana or Maharashtra, most of the builders register. So if there is a dispute, they stand on a better footing. In Tamil Nadu, they never do it. In fact, it was, I think 2013, 1st November, the Tamil Nadu government wanted everything to be registered. They were charging only 2% of the, like construction costs, they were charging only 2%. All these persons protested. And like our auto fare, nobody probably bothers. So there is a law that it has to be registered, but nobody does it. So in cases where 45(5)(a) is not applicable, these decisions can definitely be referred to. Even in the case of 45(5)(a), there can be sale of only a portion of the flats. If it is a big, when say 10, 12 apartments are being constructed, they can sell say 6 apartments and offer tax. Then others. So but the certificate of completion should have been obtained. But if the property is transferred before the completion certificate is obtained, then 45(5)(a) is not applicable, then the provisions of section 45. Because 45(5)(a), as you rightly said, says, notwithstanding anything contained. That is non-obstant clause. It's a separate section by itself.
Thank you.
Kantabai versus assistant CET. The facts that the assessee entered into a joint development agreement during the assessment year 10-11 and based on the sale of flats offered income under the head capital gains for the assessment years 10, 11, 12, 13 and 13, 14 respectively. The assessing officer will completing the assessment for the assessment year 12, 13 on 30th March accepted the capital gains admitted by the assessee but denied exemption under section 54F of the Act by stating that the transfer took place on 12/12/2009 pertaining to the assessment year 2010-11. The property was when the property was handed over for joint development and period for claiming exemption under section 54 read with 54F had lapsed. The assessing officer also issued notice under section 148 for the assessment year 10-11 by stating that the capital gains income has escaped. The issues that arose were charging a capital gains for the assessment year 10-11, consequent denial of exemption under section 54 read with 54A for the assessment year 12-13, reliance was placed by the tribunal on the decision of the Supreme Court in the case of Balbir Singh Maini for the proposition there is no transfer during the assessment year 10-11 as the JDA was not registered. The tribunal agreed with the contentions of the representative of the assessee. There is no contract in the eye of law in force under section 53A of the Transfer of Property Act 1882 after 2001 unless the said contract is registered. This being the case, it being clear that the said JDA was never registered, since the JDA has no efficacy in the eyes of law, obviously no transfer can be said to have taken place, held that the capital gains arising from the sale of movable property in this case can be assessed in the year in which the registration of the property is executed. This is one way of looking at things. Then, in the case decided by the Supreme Court in the case of Sumeru Soft Private Limited, the assessee entered into a joint venture, actually should be joint development agreement with the developer. I mean, all these words have been taken from the decision of the tribunal. So, should be joint development agreement with the developer and received a refundable deposit in Sumeru Soft Private Limited versus ITO. Possession and development rights were given. Possession as well as development rights. The assessing officer treated the same as transfer and assessed long-term capital gains thereon. The assessee's contention was that there is no transfer under section 247(5) and 53 of the Transfer of Property Act. There is no transfer under section 247(5) and section 53 of the Transfer of Property Act was not applicable as the status of the property remained vacant and no development took place. That is more important. The developer did not carry out any activity with respect to construction because the project might not be successful. Therefore, the assessee may be called upon to refund the deposit. The lower authorities up to the tribunal did not accept the assessee's contention as the assessee had allowed the developer to enter upon the project of the land for the purpose of construction, open the site and raise loan for construction. The tribunal, while it is order dated in Sumeru, etc., while upholding there is a transfer under section 247(5) of the Act, recorded that the possession and control of the property already vested to the transferee, and that apart, the joint development agreement was not cancelled, was still in operation. The High Court, however, held that the now up to the tribunal, the position was the transfer had taken place. The High Court, however, on appeal held that in the light of the ratio laid down Balbir Singh Maini as affirmed in Seshashahi Steel, etc., the questions regarding the transfer eligibility tax with reference section 247(5) read with 53 of the Transfer of Property Act was remanded to the assessing officer for fresh consideration and adjudication. This case was decided in 2020, so must have been decided by the tribunal. We do not know what is the latest outcome. Now, the ITIT Bangalore bench in the case of Aromatic Engineering Limited versus Deputy CIT held that registered GPA executed by the assessee along with JDA in favour of the developer must be regarded as a transaction in the eye of law, which allowed not only possession of the property but also various rights. It could rightly be considered as part performance of the contract as per section 53 of Transfer of Property Act. In fact, in one of the cases, the question that was required to be answered was whether GPA, General Power of Attorney, can be considered as a document registered under section 45(5)(a) of the Act. I think the issue is still pending. So in this case, GPA executed by the assessee along with JDA in favor of the developer must be regarded as a transaction in the eye of law, which allow not only possession of the property but also various rights. So it could rightly be considered as part performance of the contract as Section 53A of the Transfer of Property Act. In this case, the assessee had entered into a JDA on 27th October 2007 with the developer for demolishing and constructing a commercial complex to be rented out jointly by the developer as well as the assessee company, as a result of which the assessee community was entitled to receive 50% of the super built-up area along with certain other facilities in the schedule to the JDA. The said developer got the plan approved for demolishing of the building and demolishing of the old building and constructing commercial complex only during September 2008. So the assessee had entered to JDA on 24th of October 2007 pertaining to the financial year 2006-07, but he obtained permission only in September 2008 pertaining to 31/3/2009. The developer registered a sale deed for one of his customers on 18th July 2011. So the assessing officer taxed the capital gains in the assessment at 1213. It is to be stated the assessee company itself though offered capital gains mistakenly in the assessment at 1213, while arguing the case before CET appeals at the time of first appeal submitted, the capital gain arose when GPA was registered consequent to entering of JDA with the developer. So that was when the agreement was one second. So the JDA was entered into on 24th October 2007. So the assessee argued that the capital gains arose during the assessment year 2008-09 when GPA was registered consequent to entering of JDA with the developer. The CET appeal agreed with the views of the assessing officer and dismissed the appeal. The tribunal on second appeal filed by the assessee referred to the judgment of the jurisdictional High Court, Karnataka High Court in the case of Dayalu, wherein the High Court, after referring to the judgment of the Bombay High Court, held as follows. Having regard to the finding of fact that the possession of the property had been handed over on this is what was held by the Bombay High Court on 30th May 1986, and cash part of it was also received. Appropriate assessment year in which the capital gain is to be taxed is only 97-98, not in the year when the entire project was completed. The tribunal finally held the capital gain was taxable in the assessment year 2008-09 itself. The assessee had wrongly filed saying that the capital gain is liable for the assessment year 2014-15. Then the argument before the CET appeals, he said it was taxable only during the assessment year 8-9, and this has been accepted by the tribunal. The appeal was allowed. The Bombay High Court in the case of Bharat Jayantilal Patel versus Deputy CET held where assessing officer issued a reopening notice on the ground that capital gain income had arisen to assessee on transfer of development rights in its land to a developer. Since assessee had merely granted license to permit construction on land to such builder but not given any possession as contemplated under Section 53 of the Transfer of Property Act 1882, there is no transfer as per Section 247(5) giving rise to any capital gain in the hands of the assessee. Thus the reopening notice was not justified. The High Court referred to its earlier decision in the case of Chadur Buch Dwarka Das Kabadia, referred to earlier in the previous case, and the Supreme Court in the case of Seshashahi Seals, etc., for the proposition transfer of property under Section 247 of the Act is complete in the year in which the builder is given irrevocable license by the landowner to enter upon the land to carry out construction. The Bombay High Court in this case extracted at para 7 of the judgment the following observations from the decision of the Supreme Court in the case of Seshashahi Steels, which were to the following effect. In order, Seshashahi Steels was a decision given by a 3-member bench, out of which probably 2 members are common with the previous decision. In order that the provisions of Section 53 of the Transfer of Property Act be attracted, first and foremost, the transferee must in part perform, transferee means the builder developer, in part performance of the contract have taken possession of the property or any part thereof. Secondly, the transferee, the builder developer, must have performed or be willing to perform his part of the agreement. It is only these 2 important conditions among others are satisfied the provisions of section 53A can be said to be attracted. So this case is also important, Bombay High Court. On a reading of the agreement to sell dated 15/5/1998, what is clear that both the parties are entered to specific performance. So all these observations are from the Seshasai decision of the Supreme Court. On a reading of the agreement to sell dated 15/5/98, what is clear that both the parties are entitled to specific performance. Clause 16 is crucial. The expression used in clause 16 is the party of the first party hereby gives permission to the party of the second part to start construction on the land. Clause 14 would therefore lead to the position that the license was given to another person upon the land for the purpose of developing the land into flat and selling the same. Such license cannot be said to be possession within the meaning of section 53A, which is a legal concept which denotes control over the land. So this being the case, section 53A, the transfer of property, cannot possibly be attracted to the facts of the case. So applying the above principles as crystallized with apex court, the action of the assessing officer was held to be without jurisdiction. Where the assessee had permitted only had granted only a license to developer to enter into the assessee's land for purpose of development, the same did not amount to allowing possession of land as contemplated in section 53 of the Transfer of Property Act. Another decision of the Bombay High Court. The Bombay High Court relied on the decision of the Supreme Court in the case of Seshasai Seals, where similar views are expressed with the Supreme Court. The SLP filed against the decision of the Bombay High Court was dismissed. The High Court had ruled that the assessee had only granted a license to developer to enter into assessee's land for the purpose of development. The same did not amount to allowing possession of land as contemplated under section 53A of the Transfer of Property Act. Then IT-80, Bangalore in the case of Kola Venkata Rama Naidu versus ITO, the observations made by the tribunal. In this case, when no possession was given in JDA, the tribunal held that no transfer has taken place. The following are the observations. The mere fact that development of the property cannot be done without possession. So this is very important. The mere fact that development of the property cannot be done without possession cannot be the basis to come to the conclusion of possession was delivered in the part performance of the contract. See, let us understand. The mere fact that the development of the property cannot be done without possession cannot be the basis to come to the conclusion of possession was delivered in part performance of the agreement for sale in the manner laid down in section 53 of the Transfer of Property Act. Merely because possession was given cannot lead to the conclusion that part performance of the contract has been done. So I think the mere fact that development of the property cannot be done without, there are three negatives. One is cannot be done, other is without possession, other is cannot be the basis. So the mere fact that the development of the property cannot be done without possession cannot be the basis to come to the conclusion that the possession was delivered in part performance of the agreement was sold in the manner laid down in section 53 of the Transfer of Property Act. So even though the possession was given, when the other person has not done what is expected of him, section 53 of the Transfer of Property Act, there is no transfer. Being so, the judgment relied on in the case of Dayalo cannot be applied to the facts of the case, as the constructive possession of the property has not been given. Accordingly, there is no transfer in the assessment here under consideration. However, we make it clear that the capital gain arises out of JDA dated to be taxed in the assessment in which the assessee actually received his share of constructed area. Then another Bangalore bench. In the case, there are a number of decisions which come up before the IT-80 Bangalore bench. And no,
so in case JDA is registered, and if you take the basis of JDA registration, the year in which the property has been transferred, given to the builder. So
guideline value of the property and the date of transfer.
Okay, guideline value. And to claim 54F?
54F also, probably if you have the calculations on both sides. Suppose you transfer only 50% of the value of the property. you take in the case of the transfer price, you take only 50% of the value of the property. Then what is the value of the property when the property is acquired? See, we are talking about resident. Suppose the property is acquired prior to 2001. You take the value as on 2001. Okay, then you index it. Then today you know the value of the property. The difference between the two will be the capital gains. If there is any other consideration, suppose apart from this one, normally we take in Tamil Nadu anywhere between 2,700 to 4,250 as cost of construction. So that is also again a debatable one. So in most of the cases where there is joint development of property, unless the number of flats goes beyond 2, there are no chances of any capital gains. Moreover, in most of the joint development agreements, what the builder or developer does is only the civil construction. You will have to incur about 10 to 15 lakhs before entering the property. So how do you make the house habitable? It is not for the department to say that what money should be spent by you before entering into the property. So any basic facilities that are provided by you can also be added. So if all these calculations, unless you get about 15 flats or 16 flats, then you are liable to pay tax. You will not be even able to have this 2 crores exemption. In such cases, what you can do is you can settle all the properties in the name of the relatives, your children or brothers, sisters. I mean, if you have got a understanding family, then all of you can enter into that agreement. Then each one of them will get properties. And section 54 says you cannot transfer the property. But transfer of property does not include settlement. So after the transaction is complete, you can get the property also settled in your name. Suppose A is the owner of the property, A settles on B, C, D, E, who are all relatives as listed out in section 56 to 7. Then you enter into a joint development agreement, you get the properties allotted, you can get the properties settled in your name.
The settlement has to be done before entering into the JDA.
No, after the properties, this settlement has to be entered before
so
entering.
So this arrangement which you are suggesting, so this within the family.
Yeah, and now the maximum exemption is only 10 crores.
Now. Yeah.
Probably from the last assessment year prior to that. So all these things have got to be taken into account. See what? But most of the cases the client comes to us only if he says he has got registration tomorrow or day after. Nalla paathu solunga sir appadima. That will be a bad day for us.
So regarding investment and claiming under section 54, how to take that value when we are filing the return based on the JDA registration?
Based on the normally in most of the JDAs they have what is called an apparent consideration. It's always better to have, because even if there is a dispute, let it be the starting point for. So apparent consideration is what is the total area of the flat. Say 1,500 into say 3,500 or 4,000. Then you are going to provide basic facilities before entering 10 or 12 lakhs. So all these things, those will be the investment, the section 54 case of GDA.
No, 54F in case, since it's a land
54F, no, what you transfer is land and building.
Okay, in case land only transfer.
Land only is transferred also, then you can add basic facilities.
So 54F can...
54F, yeah.
So,
but you ensure that you don't have more than one house. And then you cannot purchase another house subsequently, probably for a period of 3 years or so. So all those conditions are really killing me. Sometimes we tend to overlook some of the conditions under 54F. Because the client may not even tell us, when a new client comes, he may not even tell us that he has already got a house property.
The value of new property value has to be mentioned in the JDA itself, that be the case.
Normally, when they prepare the apparent consideration, they will say they will adopt 3,500 rupees or some amount for arriving at the total consideration. But I have seen documents even without consideration.
If that be the case, how to determine the value to claim exemption under section 54F? In case value is not there.
Yeah,
because even at that time there may not be any sale also by that when we are filing the return. So at that time there is no realization also, and there is no actual sale also. Maybe that building also may be partly completed. So if that be the case, when we may have to complete the assessment and filing the return, so how to take the value?
Then it's only you can get it valued. So suppose you enter into a JDA, you have been allotted certain flats. after retaining say one flat, you are selling the other 2 flats or 3 flats. You have been holding the land since long. So the sale of land, after all you are selling a building consists of land and building. So this land on which the building stands was not transferred. On your land he is constructing and giving it to you. So the land is a long-term capital asset, building is a short-term capital asset. How do you normally allocate between land and building? Approximately we take 75% towards land, 25% towards building. So sometimes you have got to have the approximation. It is not for the officer to say what should be the value. He can't sit in the air conditioning room doing faceless assessment and say what I should do. So in the case which arose before IT, in the case of Krishna Prasad, during the course of assessment, the assessing officer noticed that the assessee with other co-owners had entered into a JDA with A for development of land belonging to them. All the co-owners were entitled to 26% of the super built-up area. The assessee share area was 12.5. The assessing officer took the view the assessee was liable to capital gains tax, computed long-term capital gains as 65, 77, 117. The CET appeals confirmed the addition made by the assessing officer. On further appeal to the tribunal, it was held by the tribunal by allowing the appeal, the assessee had given only permissive possession and not legal possession. So again another IT, it's all almost similar cases. Now we come to section 45 5A, sir. This 45 5A was introduced so that disputes in respect of joint development agreement with regard to the date of transfer can be reduced. But it is not so, in my humble opinion. So this section was introduced by the Finance Act 2017 with effect from the assessment year 18-19. And the purpose of inserting this section was explained in clause 22 of the notes and classes accompanying the finance bill. So whenever you get a doubt, you always refer to the finance bill, and there is always a note on classes or a memorandum explaining the purpose for which the amendment has been made. Under the heading special provisions for computation of capital gains in the case of joint development agreement, thus under the existing provisions of section 45, capital gain is chargeable to tax in the year in which the transfer takes place. And we are not sure when the transfer takes place. It says under the existing provisions, capital gain is chargeable to tax in the year in which the transfer takes place, except in certain cases. The definition of transfer inter alia includes any arrangement or transaction where any rights are handed over in execution of part performance of contract, even though the legal title has not been transferred. In such a scenario, execution of joint development agreement between the owner of immovable property and the developer triggers the capital gains tax liability in the hands of the owner in the year in which the possession of the immovable property is handed over to the developer for development of a project. With a view to minimize the genuine hardship where the owner of land may face in paying capital gains tax in the year of transfer, it is proposed to insert a new subsection 5A in section 45 so as to provide that in the case of an assessee being individual or individual family, I do not know why it is restricted to HUF and individual family, not to firms and companies, who enters into a specific agreement for development of a project. The capital gain shall be chargeable to tax as the income of the previous year in which the certificate of completion for the whole or part of the project is issued by the competent authority. It is further proposed to provide that the stamp value of a share being land or building or both in the project on the date of issuing certificate of completion has increased by any monetary consideration received, if any, shall be deemed to be the value of the consideration received or occurring as a result of the transfer of the capital asset. So the date on which the certificate of completion is required is very much relevant, and the stamp value of his share being land or building or both, etc., that will be the value which will be taken for the purpose of computing capital gains. It is also proposed to provide that the benefit of this proposed regime shall not be applicable to an assessee who transfers his share in the project to any other person on or before the date of issue of the certificate of completion. It is also proposed to provide that such a situation, the capital gains as determined under general provisions of the Act shall be deemed to be the income of the previous year in which the transfer took place and shall be computed as per provisions of the Act without taking into account the proposed provisions. So the agreement is not registered, then it will be covered by section 45. It is also proposed to define the following expressions: competent authority, specified agreement and stamp value for this purpose. It is also proposed to make consequential amendment to section 49 so as to provide the cost of acquisition of the share in the project being land or building or both in the hands of the landowner shall be the amount which is deemed at full value of the consideration under the said provision. These amendments will take into effect from 1st April 2018, that is 1819. So, but what is the genuine concern of the taxpayers? Now, joint development of the property is the order of the day. However, controversies loom large with regard to the date of transfer, which would determine the year in which the capital gains tax liability would arise. If anybody is going to get a notice from faceless assessment, you can be rest assured there is going to be a dispute with regard to the date in which the property has been transferred, unless the officer understands. See, even when you have assessments face to face, it's very difficult for us to make them understand. In the case of fortunately, in the case of international taxation, there is face-to-face assessment. We are able to probably satisfy the officers. But in the case of otherwise faceless, it becomes difficult. So this is in spite of the enactment of section 45(5) of the Income Tax Act with effect from 1/4/2018, assessment in 1819, as per which capital gain liability gets triggered only after certificate of completion for the whole or part of the project is issued by the competent authority. This newly introduced provision is in contradiction as understood then with the pre-amended provision whereby capital gain liability got triggered the moment the property was put in possession of the builder developer. But there are no proper guidelines in this regard in cases where the developer does not complete the project in full but completes the project partially and hands over a few residential properties with proper completion certificate, as a result of which the assessee pays capital gains tax or claims exemption on that portion of the property, but the developer leaves midway and the project remains incomplete, resulting in loss for the assessee owner. The Supreme Court in the case of Balbir Singh Maini has given a new dimension, at least so far as my understanding is concerned, has given a new dimension to the concept of transfer under section 247(5) of the Act after an amendment to section 53A of the Transfer of Property Act, as well as section 17 and 14 of the Registration Act with effect from 24 September 2001. The assessment here concerned was 2007-8. The Supreme Court in this case held, that is in the case of Maini, held that where for want of permissions the entire transaction of development of land envisaged in joint development agreement fell through, there would be no profit or gain which arose from the transfer of capital asset, which could be brought to tax under section 45 read with section 48 of the Act. A mute question which is likely to arise or crop up is whether there is a change in thinking in legal circles with regard to definition or stroke concept of transfer consequent to insertion of section 45(5) of the Act under the heading special provisions for computation of capital gains in the case of joint development agreement vis-a-vis the decision of Supreme Court in the case of Balbir Singh Maini. One is Balbir Singh Maini decision has been given. Second is amendment to insertion of 45(5)(a) with effect from assessment in 1819. My humble submission is the answer cannot be given as no, though there is no change in the definition of transfer, and section 45(5)(a) speaks of taxability to capital gains in respect of transfer in the year in which the agreement is registered, and it starts with a non-obstantive clause in the sense that the section start with notwithstanding anything contained in subsection 1, indicating there are other cases not covered by this section. That's what I said. There are other cases not covered by this section. That is 45(5)(a) is not applicable. You can always take the help of other decisions which you have already referred to. However, number of decisions have been rendered by various judicial authorities interpreting the decisions of the Supreme Court in one way or the other with regard to the year of transfer in respect of joint development agreement. One such is a decision given in the case of Sumeru, 2020 decision. The High Court listed out the arguments raised on behalf of the assessee, which were to the following effect. The reliance was placed on the decision of the Supreme Court in the case of Balbir Singh Maini and Seshashahi Steel to buttress the point that the income from capital gain on a transaction which never materialized at best can be termed only as hypothetical income, the assessee did not acquire any right to receive the income. It is to be noted that a 3-member bench in the case of Seshashahi Seals affirmed the view of the 2-member bench in the case of Balbir Singh by holding that a license to enter the land could not be said to be possession within the meaning of section 53A of the Transfer of Property Act, which is a legal concept and denotes control over the land and not actual physical possession of the land. This being the case, section 53A of the 1882 Act could not possibly be attractive to the facts for this reason alone. The Madras High Court in the case of Sumeru etc. referred to the relevant observations made by the Supreme Court in the case of Balbir Singh Maini with regard to possession vis-a-vis real income and to set aside the questions back to the assessing officer. In order to overcome so much of uncertainty, let there be clear definition of joint development, and if required, let there be a separate subchapter or subheading in capital gain chapter itself. But today I think we have got the new bill. The new bill, I mean, less said the better. I mean, there are I think 25 sections in capital gains. Like our Companies Act 2013, sections have been all renumbered. And I think there are about 500 and, of course, all these ABC, everything has gone. There are 536 sections and 16 schedules as against 298 old Act and 14 schedules. Hope, of course, a lot of homework has been done with the finance minister and the team. Hats off to them. I mean, let us at least hope. And there, they could have added a separate chapter. They could have addressed some of the issues. In fact, I have given this through our institute about 3-4 years back, as soon as this was introduced. It was brought to the notice of the, must have been brought to the notice of the finance minister then, but no action has been taken. So let that, because when the joint development of property is the order of the day, it brings so much of revenue to the government. By the builder, by selling the flats, by the owner by way of capital gains. So the issue of joint development agreement has not been properly addressed to, with great respect to the legislature. I am making this submission. So the real estate sector and players involved in the form of assessees.
In case of 45A, and if the completion certificate has not been obtained, so whether it can be deferred any number of years without getting the completion certificate so that it need not be...
I think there is a decision of some tribunal. If it is not possible to get the completion certificate, you can't hold it on for a long time. So it all depends upon the facts of the case and how the case is also present. Suppose if there is any genuine difficulty on the part of the developer in getting it, then probably you may take a stand that it has been completed. You can put forth all your views, but unfortunately, chances of winning before the first appeal are very remote, because they are also faceless. No, they want to make even the tribunal faceless. So at least when you submit all the papers before the tribunal in person, yes, you have got good chances.
In some cases, if the flats are less than 8, the completion certificate is not mandatory. In those cases,
mandatory of obtaining certificate.
Yeah.
Maybe
the authorities are not issuing the completion.
Maybe it is, if it is less than 30 lakhs. Then the date on which you get this corporation receipt. If you know, in olden days, we were all very much interested in getting a receipt from the corporation, even though we have not occupied it for various reasons. So that is one of the pieces of evidence. And or maybe getting, at least getting electricity, they may not agree, because the electricity connection may have been obtained even when the property was under construction. So the property tax receipt is a good piece of evidence.
So one of the lawyer of my client, even though got the possession, since it is mentioned that completion certificate has not been obtained, so that I will not present it for income tax at all. So whether that view can be taken?
No. So the real estate sector and players involved in the form of assessees entering into JDA have to be sure of their liability when they enter into such agreements, and domicile sword should not be hanging over their heads forever, which by very definition of the phrase means placing the assessees in such a situation in which something very bad could happen to them at any time. Legislature should protect such assessees who enter into joint development agreement, who not only provide funds to the exchequer by way of taxes, but also contribute to the housing sector as original owners of the property by handing over the property for joint development. Now, I am trying to give a solution. If the transfer is complete as explained by the Hyderabad bench in the case of K. Vijayalakshmi. Vijayalakshmi, the possession was handed over, the money was received, everything was done. So the Hyderabad bench said the transfer has taken place. And by the Chennai benches in the case of Tamil Nadu Brick Industries, the same thing. And Sri Satak, where the table was prepared, comparing with Baini and the assessee's case. So when there is no fallout either from the owner, assessee or the developer, the liability to capital gains tax arises in the year of handing over possession of the property. But even in this, see, we do not know today whether the fellow is going to complete it or not. As on date, suppose I hand over possession, he has given me money. The time for filing my return has already come. I filed my return, pay the taxes. Suppose next year this fellow files. We cannot always relate back to the old period, no. But even here happenings taking place in later years cannot be migrated to early years determining tax liability for such early years. But in cases where the developer agrees to give cash consideration does not mean physical cash but money consideration. The same is deferred to be received in later years on the sale of one or two properties to be constructed by the developer on his account, and only license to enter the premises is given without any registered document. The liability to capital gain arises only when the cash consideration is received. The capital gain liability will have to be calculated proportionately. The developer undertakes to dispose of the few of the properties to be allotted to the owner. The capital gain liability will arise in the year of receipt of payment from the developer in respect of sale of such properties. I mean, we should understand one thing. We give our property for joint development. So the first set of transaction ends there. Then out of the properties that have been allotted to you, you sell a few properties. So the sale brings second set of transaction. Even if you have not paid tax in the first set of transaction, the legislature or the department cannot refuse to allow you to claim this. What would have been the cost on the date the JDA, the flats are handed over to you. So when two sets of transactions, first transaction when JDA is entered into, I'll just explain how the consideration has got to be calculated. Second set of transaction, the difference between the selling price and this, as I told you, land is long term, building is short term. Building is, if it is sold immediately. The authority for advance rulings in the case of just piecing voices concerned as no remedy was. So the transaction, JDA transaction fails or falls through, there is no capital gains tax liability. And it is one of the earlier cases, this Jaspreet Singh Sarkaria voice is concerned as no remedy was provided to the transferor in case of collapse of the joint venture for whatever reason. So this can be found in the following words. This is what the ruling said. We have to advert to one aspect which has caused some concern to us. What will happen if during the year following the one in which the deemed transfer took place, the proposed venture collapses for reasons such as refusal of permission, the developer facing financial crunch, etc. By the time the owner would have received only a part of the agreed consideration, but is obliged to file the return showing the entire capital gain based on the full sale price, whether or not received during the year or deemed transfer. Such an eventuality, hardship may be caused to the owner who would have paid full tax. Now this has been addressed by Balbir Singh Maini as we have seen it earlier. Now, these are all the practical difficulties which are faced by NRIs after the introduction of section 45(5)(a). As you said, when does the transfer take place? See, there are two issues that are being faced by NRIs whenever they apply for a nil or lower deduction certificate under section 197 of the Act. But now the chances of getting lower deduction certificate are very little because no indexation is given to them unless the NRI sells the property for the same price at which it is acquired and the market price is also in tune with the agreed consideration. So in such cases, the first one is hiccups in issuing a lower deduction certificate with income tax authorities. Though a new section 45(5)(a) was introduced by the Finance Act effective from assessment year 2018-18, as per which the capital gain liability gets triggered only when the completion certificate is obtained by the builder in cases where the JDA is registered, yet controversy still exists in the case of non-resident Indians when they apply for a certificate for lower deduction of tax under section 197 read with 195 involving cash consideration which will be received as soon as JDA is signed, but where the liability to capital gains tax would arise in a later year. I enter into a transaction that is cash consideration, but 4558 is registered, so my liability arises only in later years. So I got to apply for a certificate. On what basis I will give my calculation? The liability itself arises only later years, and any advance paid to anybody is subject to TDS. All of us are aware. Even if you pay some advance to a builder, you have got to deduct and pay it. So on what basis will the department do? So this issue can be explained with the help of some assumed facts. 3 NRIs owning an residential property purchased 10 years ago, jointly having equal share, proposed to enter into JD with the builder on 1st March 2025 for developing the property, and they would be allotted 1 residential flat each, and the builder would take 4 flats. Apart from the allotment of 3 flats, the builder promoter would also be making total payment of 3.30 crores as cash consideration through bank on 1st March 2025 to be shared by them equally. The JDA would be signed. The builder and the NRIs as the owners propose to register the ADA. The flats will be ready in occupation in all respects only in the month of January 2027. The NRIs do not propose to invest in any residential properties or capital gain bonds, and taxable capital gains for each of them say works out to 140 lakh. They have got no other source of income. They are willing to pay capital gains tax on this capital gain. They are willing to pay tax on this capital gain. As per the amended provisions of 45(5)(a) of the Act, capital gain liability would arise only during the assessment year 2027-28, because the certificate will be obtained only in the month of January 27, whereas cash consideration is received during the assessment year 25-26. So the questions arise: should tax on cash consideration of 3.30 crores be deducted by the builder at the appropriate rate of 14.95? So actually only following questions. The capital gain liability would arise only for the assessment year 27-28, whereas the cash consideration is paid during the assessment year 25-26. Can the NRIs being transferors apply for a certificate under section 197 read with 195 in the month of March 25, requesting the assessing officer to direct the builder promoter to deduct tax at the appropriate rate based on the calculations to be submitted by them, which should be much lower than 14.95. When capital gain liability itself does not arise for the assessment year 25-26, you understand? When there is no liability to pay capital gains tax, but you have received some advance, what calculations can NRI submit? What orders can be expected from the assessing officer? All documents are to be submitted now electronically, and generation of certificate is also done electronically through the system, in the sense no certificate stroke direction or letter. In olden days we used to get some letters saying so much of tax has to be deducted during this year, so much of tax has to be deducted in the next year, subject to payment of 50 lakhs in capital gain bonds. When we were permitted to invest more than up to 1 crore in capital gain bonds, we are all doing it 2 successive financial years. Now everything is generated electronically, and interaction with the department is also limited. Now in case, another one, in case the NRIs decide in this case to invest 50 lakhs in capital gain bonds, so there would be tax liability only in the balance of 90 lakhs. As TDS provisions are applicable for advance payment also, NRIs cannot keep quiet, so also the builder promoter. When provisions of section 197 read with 195 are available for less deduction, how to enforce them in this peculiar situation? Deduction of tax at a higher rate would be detrimental to the NRI. The tax liability would be far less or nil, as the case may be. So the relevant section requires suitable amendment. Who is going to listen to us? Even my wife doesn't listen to me. Do you think the finance minister of the government is going to listen to us? It should be understood that on any payment made to a non-resident seller by the purchaser, whether he is a resident or non-resident, that is, whether the purchaser is a resident or non-resident, if any payment is made to a non-resident, tax has got to be withheld and paid to the government by the purchaser on the full rate of cash consideration. Suppose for purchasing this some capital gain bonds, I take another 50 lakhs advance from the buyer of the property or the purchaser of the property, that will also be subject to higher rate of tax. So how to go about it? So the second issue is the methodology that is being adopted by the income tax department while granting approval for low deduction of tax vis-a-vis proposed investments, etc. So the income tax authorities, by following standard operating procedure, popularly known as SOP, issued by the Principal Commission on International Taxation, state that they cannot take cognizance of the proposed investment in capital gain bonds or a new capital asset, and tax will have to be withheld by the buyer of the property even on those amounts. Suppose I sell a property, I want to invest in another property, I give a declaration, even then they do not accept it. So you should start trusting NRIs. This attitude is resorted to by the income tax authorities in spite of NRIs filing an affidavit. I have filed an affidavit in one of the cases like this. This is further to state that as aforesaid, I shall be investing a sum of rupees 50 lakhs in capital gain bonds in purchase of a new capital asset by opening a capital gain scheme account 1988. If need be, necessary directions may be issued in this regard to the purchaser of my property to withhold the amount from payments to be made to me and invest on my behalf in my name in capital gain bond and open a capital gain scheme account in my name. What is the problem for the department to issue such a letter? Because they say everything comes from. No, about 6-7 years back I was able to get all directions there. They used to even give it in handwriting. The income tax officials insist that the new capital asset should have been purchased within the time specified prior to sale of the capital asset as provided in section. One officer said, property வாங்கிட்டு வாங்களே நான் கொடுத்துட்டு போறேன். 54F of the Act and a deposit should have been made in capital gain bond when application is made. Is this possible? Does not the procedure that is being followed now amount to rewriting of the Act? Act never says so. Some officials suggest that advance can be taken by NRAs from purchases of the property and investment can be made out of the existing funds to fulfill these obligations. If an NRA were to take this suggestion seriously, then the money to be received from the purchaser for the purpose of this investment would have to be grossed up, and this amount would be a staggering amount as tax would be deducted at the rates in force as stipulated in section 195. If this is also added, a gross amount will be a larger amount, so the tax will have to be deducted on the larger amount. You don't save anything. The rates in force as stipulated in section 1, because this receipt would be an uncovered one, not covered by certificate to be issued by the assessing officer. With regard to the second part of the suggestion of utilizing existing funds for investment in capital gain being a residential property and or capital gain bond, it is not advisable, as the income tax department during the time of faceless assessment may disallow the investment as the same as not emanated from the sale process of the property. Though the Act provides you can purchase within 1 year, the department may say that we have not accepted this decision or that decision. Though there are a number of precedents favorable to the assessee that the investment in new property need not come out of the process of the property. The NRA then will have to face faceless appeal. If he is not successful before the first appellate authority, he will have to prefer an appeal before the Income Tax Appellate Tribunal. As per the amendment to the proviso to section 254(2)(e) of the Income Tax Act, the ITAT may grant stay under the first proviso subject to the condition that the assessee deposits not less than 20% of the amount of tax, interest, fee, penalty or any other sum payable to the provisions of the Act, or furnish security of equal amount in respect thereof. Moreover, by not permitting the NRA to invest in capital gain bonds because of excess withholding of tax directed by the assessing officer on account of not considering the investment in capital gain bonds, our country would be losing the inflow of funds into the system of investments. So this cannot be the intention of the legislature. So the government is requested to take necessary steps by issuing the required instructions to income tax officials in this regard. Now, when constructed flats are sold, in the case of JDA, transfer of property takes place when the property is given for development. The flats allotted on developed property and handed over to the owner are sold. Transfer of property again takes place with regard to such properties. The ITAT bench in the case of Asif Khalil has explained this concept lucidly by stating that liability arises at the time of entering into agreement, and sale consideration would be the fair market value of the constructed area, and the assessee was to receive including any consideration in terms of the agreement. The flats are sold subsequently. The fair market value of the constructed area becomes a cost of acquisition, and interest cost has to be deducted in order to arrive at capital gains. The tribunal held even if there had been any failure to declare capital gains on entering into the joint developer agreement first, claim to deduction of cost of acquisition cannot be denied when the constructed flats are sold during resulting in capital gain second time. So, merely because first time I have not done anything, you cannot refuse. To put it in simple terms, in respect of flats that are sold within a stipulated period of 24 months after handing over is affected by the builder developer, the land on which the building stands would be subject to long-term capital gains. You are asking about 54F. 54F, you cannot sell your allotted flats like this because there are restrictions. 54 you can do. So put it in simple terms, in respect of flats that are sold within the stipulated period of 24 months after handing over is affected by the builder developer, the land on which the building stands would be subject to long-term capital gains, the period being counted from the original date of holding as such portion of that land had not been ceded to the developer. However, sale of buildings would result in short-term capital gains. In this regard, reference may be made to the order passed by the ITAT Chennai bench in the case of Assistant CAT vs. Ram Mohan, wherein this concept has been lucidly explained. The Madras Tribunal says you can take the Galilean value of the land on the date on which the transfer took place. Now, a few note of caution. It should be noted that before entering into a joint development agreement and handing over the residential property for development, the residential building, however old it may be, should not be demolished by the landowner, as otherwise the transfer would be treated as a transfer of land only, and the benefits available for transfer of land and building would not be available. 54F. In other words, benefits arising out of such transfer would be restrictive, as only exemption provisions of section 54F would be applicable and not the enlarged benefits available under section 54 of the Act. The Karnataka High Court in the case of CET was the Ved Prakash Rakra held that where before entering into a JDA and handing over residential property, the assessee himself demolished the residential property, then he cannot claim the benefit of deduction under section 54 of the Act. So we require case law even for this. So other important points. It is essential to take adequate care in drafting a JDA so that there is clarity with regard to data transfer of land and building. The Madras High Court in the case of CAT vs. Busand Raj has cautioned that in jurisprudence, intention would be irrelevant, and transfer of a capital asset which is complete in itself cannot escape tax liability merely because the intention of the assessee was otherwise. Again, I am quoting one old Tamil movie. If you stretch your hand, you can take it back. If you stretch your leg, you can take it back. But if you stretch your neck, the thali is tied, nothing could be done. So capital gain is like that. The liability arises, finished. So intention would be irrelevant, and so whatever may be your intention, but how you express it in terms, and the transfer of capital asset which is complete in itself cannot escape liability merely because the intention of the assessee is otherwise. In other words, if any action is done with contrary intention, it becomes within the mischief of attacking statute, it cannot escape tax liability for that year. Now, the benefit of exemption available to two residential units can be taken advantage by resorting to settling the required portion of the property in favor of the ultimate beneficiaries in cases where the residential property with appurtenant land proposed to be given is huge and substantial number of flats are to be allotted, so that each of the beneficiaries joining together with the settlor can enter to JDA and claim exemption for two residential units. Of course, the capital gain should be less than 2 crores. When you have got more number of persons, capital gain available to each person has to be calculated, not the total gross. The provisions of section 56(2)(10) of the Act with regard to treating a benefit accruing to a person as income in the case of inadequate consideration arising out of transfer of a capital asset that we kept in mind. In this case, suppose the JDA is entered into, that builder developer gives you more than what is normally acceptable, then the balance will be taxed in the hands of the owner under other sources. Now, as I told you, basic facilities such as interior, decor, including woodwork, fitting of air conditioners, electrical work, modular kitchen, the jointly developed property will form part of investment in residential property for the purpose of claiming exemption under section 54 of the Act, because when the developer hands over the property, there would only be completion of civil construction without these facilities, which are required before the owner steps into the property or lets out to the tenants to make the house habitable. So I have also referred to a tribunal decision. So this is a presentation so far as joint development of property is concerned. So you can ask me questions, sir, before you go to Finance Number 2 Act. Any specific questions? One second.
Sir, once hello.
கொஞ்சம் ஆன் பண்ணி கொடு.
Hello. Okay. Sir, once we paid the tax, capital gain tax under section as per JDA, we can't get back it.
Unless you prove that the transfer has taken place in a later year. And in this faceless, how will you do certain things? Even you are not able to make an application
154?
under section 154. We find it sometimes difficult. You are given only two options. Like a person entering a witness box, say yes or no. Where did you see this or did you not see this? That's why before entering into JDA, let the client come to you, then you properly advise him. But as I told you, most of the cases they come after everything is done. They will say in the audit இப்படி சொல்றார், எங்க வக்கீல் இப்படி சொல்றார். Then ask your வக்கீல் to file the return. Then why do you come to me? So as a last resort, they come to a chartered accountant, sir. Sometimes your hands are tied. And you are also not able to tell him frankly. But it's better to tell him frankly, yours is a difficult case because anyway, let us try. Then we take the help of all these case laws and other things. In fact, I myself have taken different positions at different points of time in different cases to suit my convenience. One case came to me from another chartered accountant where when the JDA was entered into, capital gains tax was not offered. Then I said only if the flats are allotted to me, I will pay. Fortunately, there is no scrutiny assessment, I was able to get things done. So till the such time, probably we have 1 year now for issue scrutiny notice. Till such time, we have got to be careful. Now 148 notices galore. They keep on giving 4 days, 5 days, 7 days time to reply. Whether 148 notice can be issued. So that they have got to do it, decide within 1 month from the end of this month. They issue a notice today, they have got to decide before the end of March whether 148 notice has to be issued.
Sir, in case of non-resident, under section 195, even if he advance paid,
Yes, subject to
it
tax.
will attract tax.
No, you suppose the consideration is say 150 lakhs. 10 lakhs is taken as advance. So you apply a certificate only for 140 lakhs. So they will issue a certificate only for 140 lakhs. The whatever tax they determine, you pay. The balance of 10 lakhs is subject to tax at full rate. If the value of the property is more than 100 lakhs, the tax effective rate is 14.95. 12.5, 15% surcharge plus 4% cess. So 14.95. If it is less than 50 lakhs, it is 12.5 plus 4, that is 13%. This 50 and 100, it is 14.3. There is 12.5 plus 10% on 12.5 plus 4%. And it is now 20%. Withholding tax and capital gains tax are one and the same. Lot of chartered accountants, lot of advocates are not. One advocate said, "Kuda pidichidam, sir. Had it been your money, will you do that?" When these fellows come to me, come to us, only they will ask all sort of questions. When you ask them to pay 10,000 rupees extra tax, when the advocate says let 20% be deducted, they will gladly agree.
Is there any possibility of changing the assessment year chargeability to other years under section 195? Because the amount paid is advance.
Okay. No, so long as you don't give possession, there is no. That's what I say. The example which I gave for NRE 3.30 crores, I get only an advance. Then if such advance is given, ask the builder to deduct full tax and pay to the government. You can file a return saying that no transfer has taken place, get back the money. Because there is no way by which you can satisfy the officer saying that no transfer has taken place. Section 195, there are no ways. Like our 194 IA, that 1% deduction is compulsory. Even if I don't have any tax liability, 1% deduction is compulsory. Likewise, 195, the provisions are so worded, it's very difficult for you to satisfy the officer. Officer will ask, then tax particular, sir, let him, then when you file the return, you get the refund. When ultimately there is going to be liability in the later year, that can be adjusted again. I mean, some sort of talk will be like that.
Thanks, sir.
Action has been taken by the bank and it has been disposed of by the bank and money has not been received by the assessee.
There is a decision of the Madras High Court which says you cannot claim it unless you get a property along with loan. Suppose I inherit a property from my father, the value of the property is 150 lakhs, the loan is 70 lakhs, so the cost of acquisition to me will be 80 lakhs. But if it is created by me, I cannot claim it. Suppose if it is a firm where father and son are partners, the liability is created by the firm. On the death of father, suppose it becomes a proprietary concern. Such cases, because there is a change in status, you can claim it. There are actually two tribunal decisions. One decision pertained to Kailasam, son of Balachandar, given about 6-7 years back. They did claim the same thing. It was disallowed. Then there is a majority decision given by the Bombay bench. They disallowed it. Then there is a decision of the Madras High Court. So they, in fact, I covered all these things in the book written by me. It's a commercial aspect of it.
Assessee has not received the consideration in this case, no sir, because it has been given as a collateral security and the assessee has not received consideration and the loan has been settled and the bank has disposed of the property. If that be the case, how the income is arising to the assessee?
See, even then, the liability is discharged on your behalf, isn't it? And the property belongs to you. In fact, in one case, the property was owned by the private limited company and the managing director had given a guarantee to the bank. Then I said there is no such liability because it has been acquired. They said any money which has been taken by the bank directly, the property belongs only to you. In my case, it belonged to the company. So the property belongs to you. You may not get possession of the property. You may not be in possession of the property as on date. But who is the owner? You are the owner. And who has taken loan? In fact, there is one old decision.
Company has taken the loan.
That's what. In the case also the same thing.
Because it has been given as a collateral security by the director.
Yeah, whatever it is. See, anyway, that money is recoverable. In fact, it is also a reported case. Geeta Subramaniam versus IT80. In 3 days, I got an order. I thought I was going to win the case. It has also been reported.
It cannot be shown as utilization under the tax.
Yes,
and in
sir.
the case of many properties have been obtained in the joint venture by applying section 45(5)(a) and as the builder is booking, that owner also booking the properties and he is also selling, and for his share he is also receiving the money, and to charge under capital gain. So as and when the advance money is received by the landowner, it has to be offered as income in the years in which it is received.
Yeah, I think that would be a prudent idea. It's better because we do not know. In some cases, actually in one of the cases where I dealt with, the third property which was promised to the assessee was never built. Then I caught hold of a Bombay High Court decision saying that even incomplete property can be sold. Then subsequent year, he gave me a compensation of around 20-22 lakhs for not completing it. Had I added the 22 lakhs, my capital gain would have been more than 200 lakhs, where I would not have been eligible to get the second house. But I offered it under other sources. There was a scrutiny assessment. Of course, in person, I was able to satisfy because that is not exactly relatable to the value of the property alone for all other facilities which are not given to him.
Sir, the converting into current assets that property, whether it be a good tax planning? before transfer of property. So
Then when does the liability arise? The liability arises when you ultimately sell it. Na?
no, when long-term capital asset is converted to current assets and subsequently given to the builder for constructing the house property, entering into joint venture, whether that kind of tax planning is also
I think,
JDA is designed, but whereas once it is converted into stock in trade, again it becomes a business income, that whatever the flats which is being converted.
all these things you will be unnecessarily be probably getting into the web. இதெல்லாம் மாட்டிக்கிற மாதிரி.
Case to case it has to be worked out. It has to be worked out case to case.
It has never been though it has been stated,
On the basis we can change it.
No, the promise given when before introduction of the new bill, they said that there is one class called not ordinarily resident. They said that will be removed. It has not been removed. They have almost copied from the old act all definitions. And one thing is, instead of assessment year, they call it as tax year. So one thing, at least tax year is a financial year. So the new one comes from 1st of April 2026, not from next year. So, and moreover, it's very difficult to manage this country, sir. So much of population, and though a few minuscule percentage of the persons pay tax.
The case was taken over scrutiny. At the time, it was explained to the AO that wrongly it has been claimed. But whereas assessee,
Yeah, you can.
AO has not permitted the commission properly implemented.
You can take the right stand. Nobody can say that you are not entitled to claim it. But only thing is, now it's right from I think assessment at 2020 when it says, unless you file a return for the purpose of claiming exemption, you are not allowed to get exemption. Suppose you have got capital gains, you have purchased another property, you don't file a return, you don't get the exemption, you will be liable to pay tax on the entire money. That's the only thing.
Claiming the wrong section, then it can be subsequently corrected later.
Yeah. Next is the மாத்தி கொடுங்க. Next. I want to come out of this.
No.
Sir, in the joint development, assuming the developer is compensating the landlord by way of rent compensation during the project time, he is staying outside. Recently, I understand the Bombay High Court says that is not an income at all for the landlord, so TDS not to be deducted. It's a capital receipt because it is for the disposition compensation. It's not taxable. Bombay High Court decision which has come.
I don't think. Though I am not competent to talk about the High Court decision, that's not the right approach.
Okay.
How do you determine payment of rent? You arrive at the total consideration. A portion you give it by way of flats, a portion by way of if there is a cash consideration, another portion by way of rent. So that is also transfer, part of transfer. In fact, there have been 2 decisions of the Bombay Tribunal earlier, but I advise my clients better. But the problem comes when the rent is given, they deduct TDS. You will get a notice mismatch. And to explain these people, it is not mismatch itself will take your life out.
Now all the developers trying to push this consideration as part of the joint development consideration.
It's better not to do
pushing
that.
on the landlords.
Because of course, the faceless now, there is no question of any jurisdictional high court, because everything is done at Delhi or in any other place.
Yeah.
But even then you can say that if there is a favorable decision from my high court, I can always. It's like this, advise people don't enter no entry. But if they enter no entry, try to help them out. Finance Act number 2, 2024 So the buyback of shares, now buyback of shares are contained in section 115 QA1. So before the amendment made by the Finance number 2 Act, it provided that notwithstanding anything contained in any other provisions of the Income Tax Act, in addition to the income tax chargeable with respect to the total income of a domestic company for any assessment year, any amount of distributed income by the company on buyback of shares from a shareholder was to be charged to tax, and such company was liable to pay additional income tax at the rate of 20% of the distributed income. That is, when the shares were acquired, were taken back by the company was liable to pay tax at 20%. Simple. Even if there is no income tax payable by the company, any shares acquired by me as the company, I have to pay 20% tax. That was the law prior to the amendment made by the Finance Act 2024. So the effective rate was 23.296, because surcharge of 12% plus 20% on 20% plus cess at 4%. Then the corresponding rule was 40 BB of the income tax rules provided the manner in which such tax was payable by the domestic company. The relevant rule provided that tax would be applicable on the distributed income, meaning the consideration paid by the company and buyback of shares is reduced by the amount which was received by the company for the issue of shares determined in the manner as may be prescribed. Such tax was applicable irrespective of the fact that the company was liable for tax on its income or not. So whatever amount was given and whatever value at which the shares are issued, the difference was subject to tax at 23.296, and no credit was available to the shareholder of the company. Now section 46A of the Income Tax Act prescribed when a shareholder received any consideration from company for purchase of his shares or other specified securities, it will be deemed to be capital gain subject to the provisions of section 48 of the Act. The amount of consideration less the cost of acquisition will be chargeable to tax under the head capital gains. So whatever money I get, whatever money I paid, the difference was to be charged to tax under section 48. Further, provisions of 1034 of the Act provided that any income arising to a shareholder on buyback shares referred to in 115 QA was exempt. Though I was subject to capital gains tax, it was exempt. As simple as this. Prior to the amendment made by the Finance 2 Act 2024, the tax was payable only by the company and not by the individual. Now, with a view to widening and deepening of tax base, and as a measure of anti-avoidance, there has been amendment on tax on distributed income of domestic company for buyback of shares. The purpose of this amendment was explained by the memorandum explaining the provisions under the heading Tax on Distributed Income of a Domestic Company for buyback of shares. Thus, special provisions relating to tax on distributed income of a domestic company from buyback of shares were introduced by the Finance Act 2013 in line with the schema of dividend distribution tax. Prior to the amendments made by the Finance Act 2020, the company had to pay dividend distribution tax on the distributed profits by way of dividends in addition to the income tax payable in respect of the total income for any assessment year. So DTA was done, that is, dividend distribution tax was payable by the company in prior to the 1st of April 2020. So the memorandum says representations have been received stating that payouts on buyback shares should be taxed in the hands of the recipients in line with similar regime in place for taxation of dividend. Both the dividend as well as buyback shares are methods for the company to distribute accumulated reserves and ought to be treated similarly. In addition, there is extinguishment of rights for the shareholders who are tendering their shares in the buyback by the company to the extent of shares bought back by such company from those shareholders. The cost of acquisition also needs to be accounted in some manner. So this is the purpose with which then it is therefore proposed that the sum paid by the company for the purchase of shares will be treated as dividend. So now from 1/10/2024, any money paid by the domestic company for the purchase of own shares shall be treated as dividends in the hands of the shareholders. Fully subject to, all these closely held companies, the directors or directors' families or the employees' families were holding shares. Suppose I have 10,000 shares and I get, say, about 10 lakhs. The entire 10 lakhs will be subject to tax under the head other sources as dividend income from 1/10/2024. And any money paid by me earlier will be treated as a capital loss, which can be adjusted only against capital gains. Suppose I am an ordinary man, my father is an employee of a big company and he got some shares. Fortunately, I inherited those shares. I sell the shares, say worth of 10 lakhs. I am liable to pay tax at the normal rates, and whatever loss that comes on account of that, unless I get a gain in later years, I cannot adjust it. So that is the purpose. That is the amount has got to be taxed in the hands of the shareholders, but under the head income from other sources as dividends. So deeming value of consideration of shares, etc., shall be taken as 0. So the value of consideration for the shares I paid is taken as 0. Then cost of acquisition is taken as 0 for the purpose of calculating your capital gains. But that remains at some portion that will be taken as capital loss to be adjusted against your income in later years against capital gains. You pay tax on the entire money, then whatever loss you get, that is whatever money you paid on acquiring the shares, you carry over as capital loss, adjusted in later years. Allowing the carry forward of this loss as capital loss, which may subsequently be set off against consideration received on sale, thereby reduce the capital gains to this extent. So they have also given example. First time I have seen the finance bill containing some examples. See, 1,000 shares, 100 shares bought in 2020 at 40 rupees, total cost of acquisition 4,000, 20 shares bought back in 2024 60 rupees, income taxable as dividend, so 20 shares at 60 rupees 1,200, so capital loss, whatever money you paid, 40 minus 20 is 600 rupees, yeah. Then 50 shares sold in 2025 at 70 rupees, so capital gain is 70 into 50 is 3,500, so minus is 2,000 is 1,500, so chargeable to capital gains is 700. These amendments will take effect from 1st of October 2004, will accordingly apply to buyback of shares that takes place on or after this date. So what is the impact of these amendments? So I mean, I'm taking an example. A company issued 25,000 shares at a price of, say, 30 rupees, where the face value is 10 rupees on 8th April 2015. Subsequently, in April 22, the company bought back 10,000 shares out of them at a price of 50 rupees per share. In this case, the company is paying 20 rupees, 50 minus 30. 50 is the money which is being paid by the company now, and 30 was the price at which it was issued. So buyback premium, this should be liable to buyback distribution tax at the rate of 23.296. This is prior to the amendment, because in 2022 the shares were bought back. So the company would be liable to pay tax at tax of 47,920, because 10,000 into 20 into 23 point, because 20 rupees is a profit. The income was exempt in the hands of the shareholders under section 1034A as it related to pre-amendment period. Now, how will it be taxed after the amendment? Now that amendments have been made to section 115 QA, 1034A, 46A, 222. 222 says it will be treated as income from dividends. Section 57. 57 says no expenditure shall be allowed. Section 194 says tax has got to be deducted, treating it as dividends. So they have done an excellent homework by amending all sections simultaneously. The exemption to section 1034A has now been removed for any buyback on or after 1st October 2024. As explained above, the consideration in respect of buyback shares will be taken as nil. Now coming to the taxability in the hand of shareholders, section 46A states that in the case of any buyback of shares on or after 1/10/2024, the consideration will be taken as zero. That is, consideration for which the shares were acquired. Where the shareholder receives any consideration of the nature referred to in subclass F class 22 of section 2 from any company in respect of buyback shares that takes place on or after 1st October, for the purpose of this section, the value of consideration received by the shareholder shall be deemed to be nil. And as per additional clause inserted, the definition of dividend has been widened, which reads as under: any payment by a company on purchase of his own shares from a shareholder in accordance with the provisions of section 68 of the Companies Act. Therefore, on a combined reading of the provisions of section 222F 46A, it can be inferred that on or after 1st October 2024, any consideration received by the shareholder due to buyback of shares shall be taxable as dividend income under the head other sources. Further, the consideration for acquisition of shares shall be nil for the purpose of section 46A of the Act, that resulting in capital loss in the hands of the shareholder. Such loss can be adjusted against any other capital gain similar to any other capital loss. Furthermore, as per the second proviso inserted by the Finance No. 2 Act, in section 57 of the Act, no deduction shall be allowed under the head other sources from such income. Such consideration shall also be liable to tax at 10% under section 194. Now, we continue the same example. Subsequently, in April 2025, that is after the amendment, the company buys back 10,000 shares out of them at a price of 60 rupees per share. The company is paying 30 rupees more per share by way of premium, buyback premium. Now, the company would not pay any tax because the company is not liable to pay any tax. The shareholders have to offer the consideration received on such buyback of shares as income from dividend under the amended section of 222F of the Act under the head other sources. As per the amendment, no deduction shall be allowed from it. Also, the amount of purchase price would be a capital loss in the hands of the shareholders. As a loss under the capital gain head cannot be set off against any other head, such loss cannot be adjusted against the dividend income. So, dividend income will be charged to tax at the gross figure. Capital loss you carry over to the next year. So, in the hands of the shareholders, amount of 3 lakhs, that is 10,000 into 30 shall be allowed as capital loss. The purchase for which, the cost at which he acquired the shares, going back to the example, 30 rupees. So, 3 lakhs is capital loss and the amount of 6 lakhs shall be taxable on other sources. Actually, has made a income of only 3 lakhs, but 6 lakhs is being taxed at the normal rate and the 3 lakhs is being permitted to be carried over to the later years, and no deduction shall be allowed from such amount. This amendment will bring a very big tax impact on the shareholders. Now they will have to pay tax as per the slab rates, which may be 30% plus applicable surcharge plus cess. The tax payable by the assessee shareholder in the case of such buyback of shares is more than when compared to the amendments made in sections 111A, 112 and 112A. The maximum rate of tax is either 20% or 12.5%. Short term 20, long term 12.5. Now they have got to pay tax at 30% on the gross amount, and whatever capital loss is there has to be carried forward to the later years. Moreover, the loss will be under the head capital gain, which cannot be adjusted against any other head of income. Thus, the benefit of capital loss may or may not be available to a particular shareholder depending on his other income under that capital gains. So, the tax payable by the company in buyback shares will be only on the income portion. So, the company was paying tax only on the income portion. Now, the shareholder or the owner of the shares has to pay tax on the entire consideration received with the benefit of carrying over capital loss to later years. This amendment that will create a big impact affecting the buyback of shares in future. In the case of non-residents, let's come to non-residents. Income received by them by way of dividend is chargeable to tax under the provisions of section 115A of the tax at the rate of 20%. However, subject to claiming benefits under double taxation avoidance agreement entered into between India and the resident country. The benefits accorded by way of tax rate as per domestic law is more favorable than TTAA. NRA can adopt domestic law, and it is otherwise he may adopt rate as per DTA. So NRA is concerned 115A. So whichever rate is beneficial he can adopt. Now, but what are the problems that are likely to arise? It is expressed in some professional circles that the situation after the amendment will not be as simple as one envisages with regard to taxation of NRIs. The reason is simple. By these amendments, two heads of income are affected. One is capital gain, other is income from other sources. On one side, because of buyback of shares, there is capital loss. On the other side, income arises under the head other sources, which is taxable as dividends. So one is capital loss. Capital loss is capital gain article is affected. Here in this case, other sources is affected. So the question that arises is, which of the article DTA reference should be made? Whether to article dealing with capital gains or article dealing with the dividends. It is noteworthy that in certain treaties, the definition of the term dividends is quite wide. Such definitions may cover the above situation. Also, in quite a lot of treaties, the capital gains are to be taxed in the source country and as per the provisions of the domestic law. Thus, it needs to be analyzed critically based on the facts and circumstances of each case on the basis of definitions in respective treaties. So, which article should do we have to refer to? However, as in the case of all amendments brought in any section of the income tax law, there will be suitable necessary instructions from the government as the situation needs and important guidelines to emanate from judicial authorities in the days to come. Now, capital gain has been rationalized. We have got only two rates of taxes, 12.5 and 20%. Now, in the short-term capital gains, the long-term capital gains has been raised from 10% to 12.5. Short-term capital gains has been raised from 15 to 20%, and the benefit basic exemption in respect of long-term capital gains has been raised from 1 lakh to 1.25 lakhs from this year. Then unlisted shares have also been brought under the provisions of 50AA, that is all debenture linked insurance linked debentures will be treated as short-term capital loss. Now, before going to this, section 112, I don't know how many of you have gone through it in detail. When the finance bill was first introduced in the parliament, indexation was removed for all. Then the government said, we are bringing back indexation for residents. They did not say for residents, they said we are bringing back indexation back. But that is not the right case. That is, the resident Indian has got the option of adopting either the indexation benefit or non-indexation benefit. If you adopt indexation benefit, the rate of tax will be 20%. If you do not adopt the indexation benefit, the rate of tax will be 12.5. Suppose after adopting this indexation rate, minus comes in respect of the property, that minus can never be adjusted against any other property, and it can never be carried over to later years. That is my interpretation. I got a property purchased long back, so I calculate by way of indexation, I get a loss of 5 lakhs. This 5 lakhs loss after 22nd of July 2024 cannot be adjusted against any other capital gains this year, or cannot even be carried over to the later years. You will just see. On this table I have shown with the property as acquired prior to 1/4/2001 or later than 1/4/2001. Up to a particular stage, maybe the old one may be more beneficial. Roughly, if the property is sold within a period of 10 years, probably the new scheme will be more beneficial, and it is to be stated that non-resident Indians cannot claim indexation at all. So the question of applying form number 13 has almost vanished. So when the property was acquired prior to 1/4/2001, now we come to section 112. The provisions of the Act, section 112 as a stand after the amendment by the Finance Act, read as under. In section 112 of the Act, in subsection 1, for the classes A, B, C, D and the first proviso, the following shall be substituted, shall be deemed to have been substituted with effect from 23rd July 2024, namely, in the case of an individual or individual family being a resident, here they say they have, the restriction has been brought. The amount of income tax payable on the total income has reduced by the amount of long-term capital gains. Had the incomes as so reduced been his income, and the amount of income tax calculated on long-term capital gains at the rate of 20% for any as simple as that. Suppose I am a senior citizen, my income is exemption is 5 lakhs. So suppose I got an income of only 3 lakhs. So I got an uncovered portion of 2 lakhs. This uncovered portion of 2 lakhs can be adjusted against capital gains. And this is not permitted for a non-resident Indian. So this has been there already. So, and subsequently it says at the rate of 12.5% for any transfer which takes place. So the first one says at the rate of 20% for any transfer which takes place prior to 23rd July 2024, at the rate of 12.5% for any transfer which takes place on or after 23rd July 2024, provided that where the total income as reduced by such long-term gains is below the maximum amount which is not chargeable to tax, such long-term capital gain shall be reduced by the amount by which the total income so as reduced falls short of the maximum amount which is not chargeable to tax. In other words, if there is any loss, that loss cannot be. So any is below the maximum amount which is not chargeable to income tax. So that means it results in a negative income or loss. That loss cannot be adjusted or cannot be carried forward. Provided further in the case of transfer of a long-term capital asset being land or building or both which is acquired before 23rd July 2024, the income tax computed exceeds the income tax computed in accordance with the provisions of the Act as stood immediately, then such excess shall be ignored. The capital gain tax in respect of profit arising from transfer of building, etc., is contained in amended clause of 112 of the Act, and among other things, this clause does not give an option to an NRA to adopt one of the two methods, taxation of capital gains at 12.5% without indexation. So this benefit is not available to NRA. Any profit on transfer of land or building by an NRA after 23rd July 2024 will be subject to tax of 12.5 without any indexation. So from the analysis of the provisions of 112 of the Act as amended as set out above, the rollback of indexation benefits as claimed in certain quarters of the press and in group discussions conducted at various levels does not appear to be fully so in the opinion of the author. Of course, while the government deserves a lot of credit for what they have done in partially rolling back the proposal to do away with indexation, yet it is submitted with respect whether the change brought in through amendment really brings out the change needed or expected or claimed in most of the quarters as rolling back the indexation proposal. They call it as rolling back indexation proposal. In the opinion of the author, it does not appear to be so, as a change in the section says, the tax computed in accordance with the new enacted section exceeds tax computed in the law as it stood before the amendment, such excess shall be ignored. Though the purpose of the amendment is not to burden resident individuals or achieve with additional taxes due to initial proposed change by doing away with indexation, yet it cannot be stated that the indexation has been restored or rolled back. So the usage of the phrase, some places they are using grandfathering, a popular sense in vogue ever since grandfathering was introduced in respect of shares and debentures held prior to 31st of January 2018, may not be appropriated in the strict sense that if one were to analyze the real benefits in the light of what happened, the headlines like rolling back the indexation proposal. Some of the experts in taxation field have already expressed their view that in view of the language in second proviso as extracted earlier, the loss which may arise would no longer be available either for set-off against other capital gains in the current year or for carrying over the next year for adjusting against capital gains that may arise in future. The author is also inclined to agree with such view from the reading of the amended section. Anyway, when the new return comes, let us see. See, we are given very little option even to think. Sometimes the returns probably the return forms overtake us. Though there is no additional burden due to the present amendment from the amendment proposed in the Finance Number 2 Bill 2024, yet can it be stated that whether earlier benefits have been restored. The field of tax planning, certainty in tax laws is absolutely essential. Will the government come out with the necessary clarification in this matter, or should clarity come only from judicial authorities? Now, grandfathering has been there from 31/1/2018. So in this case, certain shares were issued, were offered to public, and the impression was created as if those shares were not eligible for concessional rate of tax. So this amendment has been made to bring clarity to that. So the gains the shares which are transferred under offer for sale that is the shares which are subject to STD or subject to concessional rate of tax. They are treated as long-term capital gains. But when the shares were initially offered for sale, and they were subject to STD, and such shares were exempt from the government, the STD was exempt on those shares at that point of time. So the question arose whether those shares are also covered. Those shares are also covered, and they have also explained how to calculate grandfathering. The cost of acquisition as capital asset, lower of the fair market value as on 31/1/2018, or the full value of the consideration received. So, second paragraph, with a view to clear the ambiguity with regard to determining cost of acquisition such shares transferred under YFS, explanation has been amended to retrospective effect from 1819, so as to exclude within an ambit even transfer in respect of sales of unlisted equity shares under YFS to the public included in IFO. This amendment is deemed to have been inserted with effect from 1st of April 2000. It's only of clarificatory in nature. Now, period of holding in respect of capital assets after the amendments made with the Finance Act has simplified the holding periods. Now there are only two periods, 12-month and 24-month, for a classification of any capital asset into long-term or short-term. Holding period of 36 months except in the case of business undertaking. If business is sold to another business, then 36 months still holds. The following table summarizes the classification. In case of business undertaking, there is still a requirement of 36 months or long-term categorization. So equity shares, what was the holding period? Listed 12 months, 24 months, there is no change. Then equity oriented funds, there is no change. The units of business trust, it was 36 months, now it is 12 months. Other units 36 months, 12 months. Preference shares, there is no change. Then the debentures unlisted, from 36 months it has become 24 months. So there is an income tax officer in international taxation. She has got the index point pasted on her on the wall. So whenever we go there, she will refer to that and say your calculation is correct. So like this, we should also have this pasted in our office. Very difficult to remember whether it is 24 months or 12 months, in some cases or 36 months, etc. But the basic point is, it is either 12 months or 24 months, except for business, except for transfer of business. So as I told you, market linked debentures, etc., specified investments. Then short-term capital loss, it was only 15%. All of you must have noticed, when you file a return, the concerned gentleman, our great assessee, will come in the month of July, 3rd or 4th week, with not less than 15 to 20 pages of list of shares that have been sold. So this is a very well thought of amendment, from increasing the tax from 15% to 20%. At least even if they do not want to pay us the amount of fees we require, that they pay more tax, at least for the exchequer. So long-term capital gains, it has been increased from 10 to 12.5, and for other assets it has been brought down from 20 to 12.5. Then in the case of gold bonds, now gold bonds are treated as capital assets. Gold bonds, there is no indexation at all. Though there was indexation prior to 23rd of July 2024, that is one of the silent amendments made. We sell any gold bond. Previously, if any gold bond is sold after maturity, there is no capital gains tax. I think that still holds good. But if the gold bonds are sold prior to its maturity, then the indexation was permitted. Now indexation is not permitted, though it has not been covered in this. So again, NRIs are not permitted to adopt the old rate of taxation with indexation benefits, have no other choice except to adopt 12.5% tax. Now, when the bill was introduced in the parliament, the following FAQ, now the government is issuing FAQ every now and then. They started from CBIC, now they have come to direct taxes also. So what are the major changes brought in the taxation of capital gains with the Finance Act? Holding period has been simplified. There are only 2 holding periods. Rates have been rationalized and made uniform for majority of assets. Indexation has been done away with then. Of course, now this asterisk is subject to change. Parity between resident and non-resident is not there. No change in rollover benefits. That is, you can still invest in 54, 54F, 54 EC. Is it a benefit extended by the government? The benefit is already there. The government is clarifying the benefit is still there, you can claim it. What is the date on which the new taxation provisions come into force? From 23rd July 2024 shall apply to any transaction made on or after 23rd July 2024. How has a holding period been simplified? Earlier there were 3 holding periods, now there are only 2. Who will benefit from the change in holding period? The holding period of all listed assets will now be 1 year. Therefore, for listed units of business, trusts, etc., holding period is reduced from 36 to 12 months. The holding period of gold, unlisted securities other than unlisted shares is also reduced from 36 to 24 months. What about the holding period in respect to immovable property? There is no change, 24 months. Please elaborate on change in the rate structure for STD paid on capital asset. Rate for short-term paid listed equity funds and units of business trust has increased from 15 to 20. The rate for these assets has increased on long-term capital asset 10 to 12.5. Is there any change in the exemption? Yes, from 1 lakh to 1 lakh 25 from the financial year 2025 and subsequent years. Please elaborate on change in the rate structure of long-term capital gains. The rate for long-term capital gains on all assets has been rationalized to 12.5 without indexation. Here there is a change, asterisk. The rate was earlier 20% with indexation. This will ease in simplifying the taxation of capital gains under EC computation. The system is going to do all the computation. For merely purpose of easing computation, calculation, how can you revise it upwards? Who will benefit by change in the rate from 20% with indexation to 12.5 without indexation? The reduction in the rate will benefit all category of assets. In most of the cases, the taxpayers will benefit substantially. But where the gain is limited vis-a-vis inflation, the benefit will also be limited or absent in a few cases. Can the taxpayer continue to avail the rollover benefits on capital gains? Yes. The rollover benefits remain the same as earlier. There is no change in rollover benefits already available under the IT Act. Therefore, taxpayers who want to save on long-term capital gains, even with new low rates, can continue to avail the rollover benefits on fulfillment of conditions as applicable. In which assets can the long-term capital gains be invested? For rollover benefits, taxpayers can invest their gains in house under Section 54 or 54A or in certain bond under Section 54 EC. For complete details, please refer to sections such and such. What is the amount up to which rollover benefits available? 50 lakhs. In other cases, the capital gain is exempt from tax subject to certain specified conditions. What is the overall rationale for changes? Simplification of any tax structure has benefits of ease of compliance, computation, filing, maintenance of records. This also removes the differential rates for various classes of assets. Wherever asterisk is there, change after the passing of the budget. Now, NRIs have to pay more tax vis-a-vis sale of unlisted shares. The government has amended the long-term capital gain rules for unlisted shares held by NRIs. As per the amendment added at the time of passing of the finance bill, finance number 2 budget, the government had removed the benefit of foreign currency adjustment which was proposed in the budget. when it was introduced in the Lok Sabha on 23rd July 2024. To explain it further, the budget introduced a flat rate of 12.5 as long-term capital gains tax for all asset cases. As per the proposed new rules, NRIs are required to pay tax of 12.5 on long-term capital gains from unlisted shares. Along with the hike in long-term capital gain rate, the finance bill initially mentioned allowing foreign currency adjustment to NRIs and LTCG arising from sale of unlisted shares. Now the proposed foreign currency adjustment has been removed. So far as the Finance Act, so as per the Finance number 2 Act, the benefit of foreign exchange fluctuation for non-residents and sale of shares and securities stands withdrawn. Current fluctuations occur when the value of one currency changes in relation to the other. This is commonly measured by the exchange rate. That is, you can convert and reconvert. That is not possible now. Now, amendment to section 56. I don't know what prompted the government to make this amendment. A new class has been introduced as inserted in subsection 2 to provide that where a company, not being a company in which the public are substantially interested, receives in any previous year from any person being a resident any consideration for issue of shares, the consideration received for issue of shares exceeds the face value of such shares, the aggregate consideration received for such shares exceeding such market value shall be chargeable to tax under the head income from other sources. Suppose the value share is only 100, I get 700 rupees from, so for each share, suppose I issue 500 shares, so 500 into the difference of 600 will be charged to tax the hands of the company under other sources. It has been decided by the government to sunset the classes of provisions of class 7B. Consequent to the said decision, amendment to class 7B of the Act is being carried out to provide that the provisions shall not apply for the assessment year 25-26. Does it mean that I can issue shares at different rates for different persons? It appears to be so. Now, amendment to section 194IA. See, 194IA was brought in to ensure that the sale of properties do not go out of the tax net. So they brought in the limit of 50 lakhs in respect of properties other than agricultural lands. But as in all cases, we were all taking refuge, saying that when the value of the individual share of the property is less than 50 lakhs, these provisions are not applicable. So that was definitely not the intention of the Parliament. There were 2 tribunal decisions which also said that these provisions are not applicable with the individual share is less than 50 lakhs. The amendment has been made now, which means the government has accepted the earlier position prior to 39/2024, saying that if the individual value is if there is more than one transferor or transfer in respect of any property, the consideration shall be the aggregate value of the total amounts paid. Suppose the value is 80 lakhs, even if there are 4 persons, 20 lakhs, 20 lakhs, 20 lakhs, 20 lakhs, one person has to be deducted on 80 lakhs. So each one of them will have to pay 20 lakhs after 1/10/2024. Though the intention of the Parliament, in fact I wrote an article saying that is, see, when 230A was there, Madras High Court in one of the cases said that the individual shares of individual person should be considered, but the Supreme Court, overruling number of decisions and affirming the decision of the Gujarat High Court, said that it is only the value, the total value of the property which is relevant, not the individual shares. So likewise, the amendment has been done whereby the value of the property is more than 50 lakhs, then 194IA 1% is deductible. Yes, sir. Even on JDA you can ask questions.
So in the case of capital gain tax, the taxpayer has to pay the tax and the loss also. Capital loss.
Capital loss?
Loss.
Capital,
The-
there is no tax on capital loss.
The dividend totally.
No, they have structured in such a way that you pay tax on the gross amount you received.
Okay.
And this capital loss is treated separately.
Okay. There is no transaction.
You are
foreseeable.
living in the main portion of the building. That is the outhouse. So the capital loss, when there is capital gain, you adjust against that. I mean, that is how it has got to be viewed. It is not as if we are paying tax on capital. Suppose you get capital gains in later years. You
Also,
can
there is
adjust the
no transaction like that.
There is no, I mean, that is the intention of bringing probably.
That is the
because-
last to the taxpayer. No?
Yeah, it's loss.
How many years that will be held out?
I think 8 years. Unlike now
Six.
in amalgamation of companies, the period starts from the original date itself, not from the date of amalgamation. That is subject to a lot of still the thick controversy is on. That is, the intention is to ensure, see, previously the DTT was paid by the company. Then afterwards it was shifted to the individual shareholders. The company was paying tax, I was enjoying all the benefits. Any dividend received by me was totally free of tax. Then when I was asked to pay the tax, then the entire money gets exposed to without any exemption. I think in dividend there is no exemption. The entire money becomes taxable.
Suppose there is no transaction on the taxpayer in the foreseeable future, the loss become.
The loss just vanishes. Suppose a person starts a business, he has been incurring losses, and on one day he is going to close his business, and probably when he realizes the money on sale of business, whether that will be taxed as business income or will it be brought as short-term capital gains, because all assets have been extinguished, or is it a slump sale thing? So all these broader things have to be taken note of. I think they have been probably addressed in the new bill. 25. I only saw capital gains, my interesting subject. 25 sections they have got, and definitions are almost have been taken from the old one, except there have been one or two. Some, I think instead of entity or something, they are calling by some other name, the individuals, etc. Either individual or this one, they made some alteration. Otherwise, simplification. Long-term capital gain arising?
Property.
Yeah, it cannot be. That is my opinion, because reading, and if you read some of this even opinion of experts from North India, they are the first ones to come out with openly with any opinion. Even the Income Tax Tribunal, some of the decisions given by ITIT Mumbai, even our Bombay Chartered Account Journal, it comes out with so much of information.
It can be set off against long-term capital gains as though calculated for on property. It can be set off.
Yeah, it can be.
It can be set off. But
Long-term-
other than property, it cannot
Yeah.
set off.
In fact, any income arising out of sale of house property, against that you can adjust long-term capital loss of shares, and vice versa. After all, everything comes under capital gains, only one head. So you adjust everything under one head, then inter-adjustment, then you go to intra-adjustment, and long-term capital gains carried over can be adjusted only against capital gains. Like I think house property loss also the same thing.
This buyback of shares, that taxing the case of assessee as the dividend income, And in case of high value shares, that even if you take Bajaj, recently they came out with buyback, and the share was bought back at 10,000 rupees, 8,000 rupees. So that 8,000 rupees is treated as dividend, and even that person has purchased in the market about 7,000 rupees in at least 1 month before or 2 months before. That cost has not been claimed.
Did he purchase from the company or he sold it in the open market?
No, this is buyback. He purchased in the open market and sold in the buyback.
To the company. Why did he do that?
Because
Probably he was not aware.
No. See, 7,000 rupees he has purchased from the market, and 8,000 rupees company is buying back. So 1,000 rupees he is making.
Okay.
And the 1,000 rupees he is paying. For 1,000 rupees if he is paying tax, it's okay. But whereas he has to pay tax on 8,000 rupees, and 30% if you calculate 2,400 rupees, he has to pay tax.
And for this loss, he has got to wait till he gets another chance of selling another shares in open.
Yeah, but so is it very harsh for the associates?
Absolutely harsh.
Unless they purchase from the company, and in the given example which you mentioned, 30 rupees and 50 rupees.
Yeah.
So there is a profit in that. So that kind of associate can pay tax, and moreover that cannot be that even the whatever money paid towards the share, it is not claimed. It is going to be adjusted against long-term capital gain in the future. Then again, it's a very big hardship to the associates.
Yes. Definitely. Yes, sir. Actually, it is not, what has been covered is not exactly tax planning, it's other subjects.
Enthusiasm, that is because of S Krishnan. So he very nicely handled both the sessions, and very interesting as well as very interacting, and answered all the questions also in a passionate manner, and it is very interesting. We thoroughly enjoyed the class, sir, and it is very useful to us, and both the sessions were very nice. And on behalf of SIRC as well as our participants, our wholehearted thanks, sir. Thank you so much.